Mr. Moga is in no way referred to, or rather, Mr. Moga in no way referred to the fraudulent actions as being committed against him by the accused or his personal funds being stolen by the accused. It is therefore clear that Mr. Moga was acting for and on behalf of Safa. Safa is the victim and therefore the complainant in the matter. As a juristic person, Safa has no eyes and ears, but its members and officers are its eyes and ears and are thereby entitled to act on its behalf. There is also no article in the Safa statutes that precludes any member or officer from laying criminal charges for and on behalf of Safa. Now I'd like to address the code of conduct for all, or rather, before I go on the code of conduct, Your Worship, I would like to reiterate that Safa is referred to as a public benefit organization, and it is also, its aims and objectives are to carry on the public benefit activity. Ideally, every member of the society in South Africa should be able to act on behalf, for and on behalf of Safa. Unfortunately, it is not practical. It has the functionaries, it has the officials, it has the NEC members, and it has the accounting officers, such as the CEO, the president, as well as, or rather the CEO and the CFO and other lesser officials. However, its highest legislative body is the Congress. The Congress only meets at a certain point, but it has the NEC, the National Executive Committee, which represents the public at large. It is made up of the federations in the country. It represents the public of South Africa, and therefore those members, by virtue of being the members, are the ears, eyes, and the custodians of the interests of Safa, Your Worship, and therefore they can act on behalf of Safa. The Code of Conduct for all legal practitioners, candidate legal practitioners, and juristic entities of the Legal Practice Council provides as follows. In terms of clause 28.6 of the Code of Conduct, Council must decline the offer of a brief if their other commitments do not reasonably allow them to discharge their duty of diligence in the preparation of the brief. In particular, Council shall not accept any brief if it is reasonably foreseeable that the risk exists that Council might, because of a conflict of interest or any other reason, have to surrender the brief. The copy of the code is annexed as Annexure 5, Your Worship. In terms of clause 58.9 of the said Code of Conduct, that is conflicts of interest involving legal practitioners, a legal practitioner shall not accept the brief if he or she has any form of relationship, including a family relationship, with a client or an opposing party which compromises or which might reasonably be expected to compromise the legal practitioner's independence. The same is still appearing on Annexure 5 attached to this heads, Your Worship. In terms of clause 58.10, a legal practitioner shall not accept a brief where a position or office previously occupied by him or her with a client or with an opposing party compromises or might reasonably be expected to compromise his or her independence. Now, based on the above clauses of the Code of Conduct for all legal practitioners, the Council should not have accepted the brief from the applicants since he has a relationship with both applicants and Safa, which compromises or which might reasonably be expected to compromise his independence. The Council had, at the time of appearing on behalf of applicants 1 and 3, a relationship with Safa. The said relationship was that he was acting on behalf of Safa in case number 037466 of 2022, a judgment of which was given on the 5th of December 2024, a day on which he appeared on behalf of the applicants 1 and 3. It is clear that he took a brief at a period when he was still representing Safa. There is Annexure 6 attached here to Your Worship, which I would like to touch on. Annexure 6, Your Worship, is a copy of the judgment from the High Court pertaining to the said case of 037446/2022, where the parties are the applicants Ledwaba Ria IV and Mushabing Wakusoli, and where the respondents were the South African Safa, Daniel Alexander Jordaan, the Safa NEC, and the Governance Committee of Safa. This is a judgment with regard to the appeal application that was made, and on the face of it, it shows the date on which the judgment was made, and the date is the 5th day of December 2024. The date further appears at the bottom, just under the signature of His Lordship Holland Amata, and it shows that the judgment was made or delivered on the 5th of December 2024. Now, on the 5th of December 2024, the counsel was in this very same court, appearing on behalf of accused 1 and 3. And the counsel informed the court on the particular day that he is not conflicted, meaning he's not acting for both parties. But the evidence before court here today shows that on the 5th of December, on the day when the judgment was granted, it is the same day that the counsel was appearing before this court. Now, what does that mean? It simply means that the counsel was still mandated to suffer on the day that he appeared on behalf of accused 1 and 3. Furthermore, the counsel was holding the position of a chairperson of Legal and Constitutional Affairs Committee of Safa during 2013 onwards. There is Annexure 7 and Annexure 8, which I would like to refer to as well. Annexure 7 shows the standing committee membership, which was approved by the NEC of Safa on the 12th of December 2013, wherein the council was appointed as a chairperson of the Legal and Constitutional Affairs Committee of Safa during that year of 2013, Your Worship. Therefore, by virtue of him being the chairperson of the standing committee of Safa, he was also a member of the Safa NEC. Annexure 8 is also a confirmation of the council's appointment to the office of Safa. This is a letter which was sent to the Secretary General of the CAF, Confederation of African Football, by the then CEO, Mr. Dennis Mambo, wherein he was reporting to CAF about the outcome of the Congress and the appointed officials of the Congress and their respective provinces from which they originated or came from. And amongst those was also the council before court, Council Arendse. He was elected, and his name appears on those that were elected on a day in question, Your Worship. If the court may just bear with me. Yes, the council's name appears on the members elected from the national list, and it appears third from the bottom, and he was from the Western Cape province. Now, based on the above, Council acted in violation of clause 58.10 in that the position scrutiny held with Safa compromises his independence. I further submit that the state is also in possession of evidence in which the said counsel would be required to testify on behalf of the state against accused 1 and 3. The said evidence refers to the 2015 Safa Congress, wherein the statutes or Safa statutes were adopted, and in which the counsel, as the chairperson of the Safa Legal and Constitutional Committee, was interpreting and or explaining the articles of Safa statutes, particularly Article 39.2 to the Congress. Now, this is in the same Congress, and the counsel was explaining and or interpreting the application of the articles to the Congress, and that is the evidence that the state has, and the state has always had the intention of presenting that evidence during the main trial, and the counsel is the witness whom the state is intending to call for presentation of that evidence, Your Worship. Based on the above submissions, the counsel is clearly conflicted, as he cannot be able to act in the interest of both Safa and accused 1 and 3 simultaneously, because the interests of both parties are in direct contrast and conflict with each other. The counsel's mandate by Safa requires him to protect and safeguard the interests of Safa. It is therefore in the interest of Safa that accused 1 and 3 be prosecuted for the offenses with which they are charged. However, the counsel's current position of representing accused 1 and 3 naturally prevents him from acting in the best interests of Safa, as required by the mandate given to him by Safa. As a legal counsel of Safa, the counsel is privy and has access to the information of Safa that may be used against accused 1 and 3. His current stance of representing accused 1 and 3 will clearly jeopardize the interests of Safa. He cannot be expected to represent the opposing interests of both parties without compromising one of the parties, especially that of Safa. I submit further that it will be unethical and in breach of legal professional conduct for Advocate Arendse to continue with his legal representation of accused 1 and 3 in this criminal matter. I further submit that it is natural that the complainant and the witnesses, as well as the general public, has an interest in this matter. There is therefore nothing untoward when the complainant and the witness or the witnesses point out any issue that has a bearing on this matter, which is relevant and which is in the interest of justice. Based on the above, the prosecutor's sources of information will naturally be the state's witnesses, and any information or further information pertaining to the case will be sourced from the said witnesses, and there is absolutely nothing wrong with receiving that information from the witnesses. It must be pointed out that the prosecutor does not hold brief for any party in the prosecution of the matter, but represents the state in prosecuting the matter on behalf of the complainant. It must further be pointed out that upon the receipt and perusal of the representations of accused 2 and 4, certain claims and allegations made in those representations necessitated further investigations by the state. As a result, part of the said investigations included obtaining certain information from Mr. Leslie Sidibe. Therefore, the preposterous claim that the prosecutor has been briefed by Mr. Sidibe is just a deflection employed to distract the prosecution from the real issues. The claim is vehemently denied with the contempt it deserves. Mr. Sidibe is indeed the state witness who will also be called to testify in due course. I have realized that the defense has wasted no time in trying to attack Mr. Sidibe's character by bringing about irrelevant, unsolicited, and unproven character evidence about him. In any event, the prosecutor has a right to consult with witnesses in the matter, and there is nothing wrong with that conduct. It is no secret that Mr. Mambo is another witness in the matter, and therefore he will continue to be consulted as and when it becomes necessary. There is also no time limit on the number of occasions the prosecutor may consult with witnesses. The prosecutor is not the litigant in the matter and has no vested interest in the matter except the professional obligation of prosecuting the matter fairly, impartially, and without fear, favor, or prejudice placed upon him by the NPA Code of Conduct. The prosecutor will therefore pursue justice without any fear of being vilified in doing so, without doing any favors to any party, and without being prejudicial to any party to this matter. I therefore humbly request this honorable court to order the recusal of Advocate Arendse from the matter before court. And that is the state's application as a court basis.
Thank you, sir. Advocate Arendse, can you reply to that application?
Yes, my lady. I appear for accused 1 and 3, and I intend to continue appearing for them until, if and when this matter is concluded. My lady, just a short while ago, my instructing attorney, who instructs me on behalf of accused 1 and 3, they are his clients. They have secured my fees. Safa in these criminal proceedings is not his client, and they've sent the CEO of Safa has sent a letter to my learned friend that Safa is not has not instructed anybody in this matter and is not involved in the criminal proceedings. But let me raise what I suppose one can call an in-line point. And my lady, far from wanting to frustrate or delay or distract anybody from concluding these proceedings, it's exactly this application that has been brought to achieve that purpose. It is quite revealing that my learned friend raises the issue of the legal practice council code of conduct, because your ladyship will see that in fact he had already on the first day breached his duty under the code of conduct by not disclosing to me, his colleague, in advance that he intends to bring a conflict of interest application. The code, and I'll just find it, my lady. Just bear with me. I'll find the relevant provision, my lady, but the code is very clear that as legal practitioners, whether advocates or attorneys, that we, as a matter of courtesy, must inform, advise one another if there's an issue which is not immediately apparent from the pleadings, that such an issue would be raised. And your ladyship will recall from the last appearance that I had responded by saying that I know absolutely nothing about what my colleague intended to raise. And I had said then, and I repeat it today, that it was intended to embarrass me. And this application continues to be an embarrassment. And I say so for a number of reasons. I'm not going to... Sorry, my instructing attorney found the relevant provision in the code, my lady. 61.12 of the code provides that a legal practitioner shall not deliberately seek to catch an opposing legal practitioner off guard. And the relevant, because your ladyship will know from reading the 342A application that this issue has never arisen, and it doesn't appear from the papers. Now, 61.12.4 provides that where a legal practitioner is intent on taking a point of law not evident from the papers, independently of any rule that of court that might apply, he or she shall notify the opposing legal practitioner in good time to avoid that opposing legal practitioner being taken unawares. He is guilty of that. And the reason why the name of Leslie Sidibe was mentioned, because I was advised that the only source from which this allegation of conflict could have arisen is from Mr. Sidibe. Of course, I know Mr. Sidibe, I know Mr. Mumble. They are previous CEOs of Safa. They are no longer members of Safa. Mr. Sidibe was banned from football in 2016 by FIFA for 5 years because of corruption and bribery. He, of course, was unhappy about it and attempted to overturn it. That decision has never been overturned. This is the irony, my lady, of this application and reliance on people like Mr. Sidibe and Mr. Mumble. Because Mr. Sidibe, as a result of his banning, has sued Safa and FIFA for defamation. That case is still alive. He hasn't prosecuted the case to finality. So much for promoting and advancing the interests of Safa. Mr. Mumble was the Safa CEO until the 30th of September 2018. And my lady, this is all in our application on affidavit. I'm not giving evidence like the prosecutor wants me to do. Now wants to call me as a witness. If I may just pause there, your ladyship will see from the list of witnesses, my name is not there. So again, he's blindsided me by saying, oh, you're going to be called as a witness. Mr. Sidibe's name is not on the list of witnesses. So with respect, my lady, he's making all these things up. The issue, according to my learned friend, that he wants me to be called to give evidence on is not an evidentiary issue. Article 39.2 or .1, whatever it is, my lady, relating to signatures on documents and contracts, it's a matter of legal interpretation. In fact, I would have volunteered to give evidence in this case if I was going to stand there, give evidence, and your ladyship would accept my evidence to say, oh well, Dr. Jordaan was perfectly entitled to sign the contracts. Believe me. Your ladyship would have failed in your duty. Your duty, my lady, is to make that decision based on the interpretation of the agreement. It is not for lawyers to come and stand in a witness box and give legal advice or give an opinion. So there is nothing that relates to the charges, and the charges relate to this GRIT contract, that's the PR people, and the Beaver contract, which is the security people. Quite rightly, for a change, my learned friend has not implicated me in any of those contracts. I don't know anything about it. I've never been involved in it, whether it's on behalf of Dr. Jordaan or on behalf of Safa. So Why he would now want to indicate that he's going to call me as witness, I'm afraid I can't help him. Similarly, Mr. Sidibe was CEO from 2010 to 2011. On what basis Mr. Sidibe is going to assist him is a mystery. So it's just entirely for atmosphere that he now throws in the names of these people. But my lady, I'm still on the in limine point. And I say this with the utmost respect, my lady. Does this court have jurisdiction to bar me from the two accused exercising their constitutional right in terms of Section 35(3) of our Constitution to a legal practitioner of their choice? This is all to do with their trial rights, their right to legal representation, their right to a fair trial. With respect, my colleagues' protestations and complaint in inverted commas should be, if he's serious about it, where must he take it? He must take it to the Legal Practice Council. The Legal Practice Council or the Bar Council. I'm a member of the Joburg Bar, the Cape Bar. He can take his pick. Lodge a complaint and say Arendse is in conflict. Here is the documentation. Here is the evidence. So, with due respect, my lady, this court doesn't have jurisdiction to determine or to make a decision in relation to this decision. It is, of course, different when the trial commences and I misbehave or say something that is out of line. Then your ladyship can cite me for contempt, send me down to the cells or whatever. But this is not such a matter. These are important pre-trial rights that my colleague is seeking to deny my clients. As early as 1960, and the case is cited in the submissions which your ladyship received yesterday. Probably the most standout case is the case of Mandela when he was in Robben Island. And he won, even though it was an apartheid government, he won a right to legal representation and moreover the right to legal representation of his choice. His choice was Sidney Kentridge and Arthur Chaskelson. And not even an apartheid state could deny him that. Now, of course, I'm not being pretentious to put myself in that league, or my clients, in fact, in that league. But that is, I'm just saying that because it underscores the absolute critical importance of that right. But my lady, my colleague stands here today. He's never. Of course, I'm inferring this from his presentation. He doesn't bring this application on affidavit. He makes submissions from the bar. So that's the other thing. This application is not properly before your ladyship. How do I engage my colleague when he makes this written submission? But if he had said things on affidavit, to the extent that it implicates me, I would respond. To the extent that it implicates Safa, I would ask my attorney, now go to Safa and ask him, what is this? Have they authorized Sidibe, Mumble or Muka to bring these proceedings against accused number 1 and 3? Now, I can give your ladyship an answer, but it's not under oath. The answer is no. The current CEO of Safa has written a letter to say, I'm paraphrasing it very crudely, but Safa has not given anyone a right to bring any charges against accused 1 2003. So that's the other issue. The first issue is jurisdiction. The second issue is standing. Now, Mr. Muka brought these charges in 2020, and of course that links to our 342A application, because so this is a case that comes on since before 2020. So he brought the case in 2020. At the time he was suspended. Subsequently he was dismissed. And again, I'm not saying this from the bar, it's in the papers, it's in the High Court papers in one of the matters that we will draw your ladyship's attention to in the 342A application, that an independent arbitrator, a senior counsel, found him guilty of inter alia bringing Safa into disrepute. And the remedy that was recommended, because the arbitrator, the remedy had to be approved at the Congress. So he was found guilty. The arbitrator recommended his dismissal, but in order to give legal effect to it, it had to go to the highest decision-making body, which is the Safa Annual Congress. And in that Congress in 2021, Mr. Muka's dismissal from Safa was confirmed. So on two bases, it is absurd to contend that Mr. Muka is acting not in his own interest but in the public interest. How can he act in the public interest when he has brought Safa into disrepute? Your ladyship will know from the statutes, and if needs be, I'll take your ladyship to the relevant clause. Safa arbitrations, like FIFA and all soccer bodies, whether it's our friends in Namibia, Botswana, Malawi, the statutes all read the same. They are final and binding. And we know from our law, it is final and binding until and unless it is set aside in a court of law. Mr. Muka has not done that. He's launched an application which is just hanging there. This is now 3 years ago. He's done nothing to bring it to bear. So he's got no standing in this matter. Your ladyship would have seen from the papers before the High Court, and perhaps if I can just get it. So, my lady, just while Mr. Nkwachu is looking for the letter, I found it. Just two things. One, I'm not on a retainer of Safa. In fact, the two applications that are currently before the Joburg High Court, and which we'll refer to in the 342A, I'm not counsel in that matter. There's other counsel in the matter. I'm not on a retainer with Safa. And the second thing is, and I don't know why my colleague didn't make it clear. Yes, at one point, because I was president of Safa Cape Town, as you may know, Safa's got 52 regions, Safa Cape Town is one of them, and I was president of that region at one stage. And by virtue of being president, they asked me to stand for the NEC, I was elected, and I served on the NEC. But that was for that limited period, my lady. I haven't served on any Safa structures since that time. So I've got no relationship with Safa. I'm not on a retainer, and I don't serve on any of their committees or bodies. And to the extent that they brief me from time to time, that is my job, that is my profession. I exercise my independence as counsel based on one matter to the next, as we are required to do. Now, the other day, my colleague's reference to Ria Ledwaba's matter. And I know Ria very well too. And we actually get on well. And Ria has brought 5 cases against Safa. She lost all of them with costs. The most recent one was dismissed on an attorney and client scale C, the highest scale. Now, what your ladyship what my colleague must answer to is, what is the subject matter of that case that now brings me into conflict with Safa or my clients? There's no conflict, because that case concerned the Safa elections of June 2022. Ms. Ledwaba participated in those elections. She lost overwhelmingly. She complained about certain irregularities. These irregularities were dismissed by the electoral officer, and in terms of the Safa statute, the decision of the electoral officer is final. After the elections took place, and if needs be, I'll find the Facebook page. Quite graciously, Ms. Ledwaba said, I accept the defeat. It's bitter, but I accept it. And I accept the outcome of the elections, but I will continue to fight on. That's typical Ria. So I wish her good luck, and in whatever way. But she's fighting on, but not as a Safa member. She's not a member of any Safa structure. Muka is not a member of any Safa structure. Sadepi is not a member of any Safa structure. Mumble is not a member of any Safa structure. There are a number of people on that witness list. They're not members of a Safa structure. The only person that stands out, and why his name is on the list baffles me, is our chairman of the league. But if your ladyship looks at Dr. Khoza's witness statement, it is purely of a technical nature. He doesn't say anything about Jordaan or Groni. And to his credit, and the reason is, my lady, he's still serving on the Safa NEC. He's still there. And like with me, like with anybody else, he has an opinion on what Article 39.2 means. In fact, if he's called, his evidence will have absolutely no evidentiary value, because he's giving an opinion on a legal matter. He doesn't say anything about the substance of the grit contract or the beaver contract. Now, my lady, let me deal with the so-called public interest matter. Safa is responsible for organizing all football in this country, amateur football and professional football. The amateur football is played in 52 regions, and they have local football associations, they have regional associations, and there's 52 of them. Our professional football is run by Safa special member, which is the National Soccer League, so in a sense it's outsourced. But the league is still subordinate to Safa. Now, every year, Safa has an annual congress, and every, I think, 4 years, they have an elective congress. And my lady, at this annual congress, and your ladyship might know from belonging to various organizations, the annual financial statements are submitted to that congress for approval. The annual financial statements is signed off, and this is a matter of, I'm not giving evidence, it's a matter of general knowledge, signed off by certified auditors. They look at your books, you must raise certain queries, and then they sign it. And the Safa statutes require the annual financial statements to be signed by the CO, the CFO, and the auditors. Now, my lady, despite And I'll read to your ladyship the part that I want to read, what Mr. Mumble wrote when he was CEO to everybody. Despite the issues that have been raised publicly and which has been attempt to smear Safa, it's the only sporting federation in this country, and I've also been involved in cricket, that have returned clean audits, clean annual financial statements routinely, and certainly under the presidency of Dr. Jordaan since 2013. Now, the point is this. The first contract of GRIT 2017 to 2018, whatever may have happened, there was no report about it because the annual financial statements, which relates to that and I suppose many other contracts, they would have been approved, and they were approved by the NEC, on which our friends Muka, Mafovani, Mumble was CEO, Dr. Khoza, they all sit on that body. Now, unless they're not paying attention or they're falling asleep, these things are put before you. And maybe I'm giving evidence. As an NEC member, I know you've got to go through these documents. It's not nice if you're not a figures person or a financial person, but it's your duty. Your fiduciary duty is to make sure that you read through these things. They've been adopted, first by the NEC, and then it goes to the annual Congress. And of course, the annual Congress, I wish you or anyone else could be there. It's a great occasion because the whole of our football is there. The whole football family is there. And that financial statement, someone from one region puts his or her hand up, another one puts his or her hand up, and it's adopted. It's been adopted in the period of these contracts, 2017, 2018, 2018, 2019. The first one, 2017, 2018, who was the CEO who signed off on these annual financial statements? Dennis Mumble. Of course, in the event, and I hope it doesn't happen, but in the event that the trial proceeds, he will in due course be asked about these things. And in the following year, 2018, 2019, the CEO was the acting CEO, Russell Paul. And for both those periods, the CFO was Mr. Groni Schroer. So they must take the responsibility for that. If there were any complaints, like Mr. Mumble now says, then it should have been raised in the appropriate forum, either at the NEC or the Congress. He gives an interview to TV. He doesn't say that I had no issues, no complaints about these two contracts or the conduct of Jordaan or Groni. He raises those issues only in 2020. And again, I'm not giving evidence. It's in the papers and it's not disputed. Mr. Muka's complaint is based entirely on what Mr. Mumble says in his so-called dossier. In other words, it's hearsay evidence. And so do all of them rely on what Mr. Mumble says. Now this is a letter. It is attached to the documents we sent you yesterday, my lady. It's marked DJ7. It is dated 29 March 2018. So this would have been a few months before Mr. Mumble, and of course Mr. Mumble didn't resign. He wasn't dismissed. Mr. Mumble in 2013 was already age 60. And the Safa pension fund requires that your employment comes to an end. So, and it's again in the papers. And his contract was extended by former President Mr. Kirsten Nematendani Mr. Nematandani extended his contract for 5 years in 2013. That is why, until March 2013, that is why Mr. Mumble had an extended period. Ironic, isn't it? He had a contract that was signed by Mr. Nematandani, the president. Under which clause would he have done so, other than section Article 39? But Mr. Mumble obviously has no issues with that. So, let me just quote to you just a few passages. This is before the Congress in 2018. Mumble says, and this is addressed to all SAFA members, all SAFA council members, of course, councillors read NEC members, from the Chief Executive Officer, and the heading is the attempts to destabilize the South African Football Association. And he says, we hope for a cordial atmosphere for debate on issues that are important to the growth and development of football, but these have been severely compromised by forces whose publicly stated objective is to ensure no elections take place as directed by the Congress, and that the Safa brand is tarnished by unsubstantiated allegations of impropriety, theft, looting, and financial mismanagement in an attempt to promote discord among Safa members. This is done to induce the financial downfall of the association. It is therefore incumbent upon us to set the record straight in respect of these allegations against the... And then he deals with defamatory statements by non-members of SAFA. He deals with the malicious disinformation campaign against SAFA. He deals with a false claim about one of the region's motion that was submitted. He deals with deceitful statement about the decision to change the elective Congress to March 2018. And if your ladyship will just have a cursory glance, it's actually a very strongly worded document, because he puts the contentions in black, and then he says the lie, the lie, the lie. So this is a man of strong conviction, but who clearly is able to change his convictions depending on where he is. In 2018, he's totally committed to SAFA. He's totally committed to dealing with these allegations. So I'm not going to it's a long letter. So, my lady, as far as the interest of the public is concerned, you can't simply walk off the street and go to Safa House and lodge a complaint. Whether it is Safa, whether it's the English FA, whether it's the Namibian FA, or any FA anywhere in the world, the English FA, they will tell you, sorry, you've got no right, you've got no, in law, you've got no standing. These persons that I have referred to, and that my colleague has referred to, they were all involved in SAFA. They had every avenue open to them to lodge complaints, but they didn't do so. They only did so after either they were not elected, like Ms. Ledwaba, like Mr. Mbuka, like Mr. Mafovani. They were not elected by the members. And then they actually blamed Dr. Jordaan. The members didn't vote them in, so they weren't elected. Others were dismissed, like Mr. Muka. Mumble's contract expired at the end of September. And so what you have, my lady, and And this is why it's not for a lady to exercise jurisdiction in this matter, because a lot of this is not under oath. And that's the problem, the fundamental problem with this application. Because we are dealing with a number of disgruntled ex-Safa officials and employees. Mafovani was on the NEC. He was the chairman of the finance committee. He wanted to become the CFO. He wanted a job. But he wanted the president, Jordaan, to give him a job. And when you tell him, sorry, I'm not here to hand out favors. I can't give you a job. Apply for the job. Maybe I can put in a good word for you, but that's the extent of it. And he's disgruntled, and that's the end of him. In fact, as a matter of interest, your ladyship will in due course see Mafovani, his statement is only procured in April this year, 2024, and it's only after this one High Court application was brought that his statement is procured. Muka was this Gay Mokoena, also previously, and again, good friend, nice guy, was serving on finance, but it's common cause that he acted as CEO of Safa for a limited period, but he wanted to become CEO, and he wasn't appointed. So all of them have a history, and so with due respect, there is nothing that they have done or is doing or are doing that is in the public interest or for the public benefit. There's a region and an LFA. This is what makes Safa the biggest region of all our major codes. Maybe not the most popular, but they're getting there, I suppose, after rugby. But they represented in every corner of our country, my lady. And as I said in our written submissions, there is no other sports federation in this country that has the kind of elaborate dispute resolution procedures in its statutes like Safa has. Of course, Safa statute mirrors the FIFA statutes. And that is why, my lady, there is a clause. And again, I can take your ladyship to the clause if your ladyship wants. There's a clause which actually says in the Safa statutes, it constitutes misconduct to take Safa to court. That's what the clause says. And it's not only in the Safa statute, it's in every other of the, 209, 211 football associations around the world. Why? Not because you want to deny people their right to take up issues, but because there are arbitration provisions, and the arbitration is final and binding. And the only recourse after you go to arbitration is to go to the Court of Arbitration for Sport in Switzerland. Now, as an official, even as a lawyer, we've had issues with that, because to go to Switzerland, and maybe Mr. Sadebi must go to Switzerland, but I think he said in his court case it's too expensive, and it is. It's prohibitively expensive. But we've been there with different clubs and different issues. That is where you go, but you don't go to court. But despite them going to court, Safa has actually never taken any action against any of these individuals. What did you give? Sorry, Mami, I'm almost done. Sorry, my lady, this is the letter that was sent, and it was procured by, and I'm for a change passing that responsibility to my instructing attorney. It's dated 10 December today, and it's from the office of the CEO of Safa. And she says, this letter serves to confirm that the South African Football Association is not a complainant in the court matter between the National Prosecuting Authority and Dr. Daniel Jordaan, Mr. Trevor Neethling, Mr. Groni Sloyo, and Grit Communications. The complainants are disgruntled former Safa National Executive Committee members and Safa employees who have no legal right to represent Safa in these proceedings, and they have done so in their personal capacities outside the ambit of Safa. Furthermore to this, both Dr. Jordaan and Mr. Sloyo will be covering their own legal costs for this matter. Safa will not be paying any of the legal costs or any costs associated with these proceedings. So, my lady, I had a number of notes here, but I think I will leave it there. Oh yeah, save, my lady, as we often do. Your ladyship received my written heads of argument in the recusal application.
Yes.
I stand by them. They make it clear that the right to legal representation is of fundamental importance because it forms part of the principle of equality before the law and is absolutely foundational to the right of a fair trial. The necessity for legal representation in criminal trials flows from two principles. One, the fundamental principle that an accused person is entitled to legal representation, and two, the equally fundamental principle of equality before the law and the application of these principles to the adversarial process. My lady, those are our submissions. I ask that your ladyship dismisses the application so that we can get on with the business of the application that is otherwise before you today, and depending on your ladyship's ruling on that one, so that we can get on with the business of bringing these proceedings to finality. Thank you, my lady.
Thank you, Advocate.
My lady, is it possible to have a short adjournment?
I'm going to have that. I just want to get Mr.
Thank you,
Ndebele
Mary.
before I adjourn, because I just want to postpone another matter. Mr. Ndebele, do you have any address on the application?
Your Worship, I've learned over the years in practice to choose my battles. This battle doesn't concern neither my clients nor myself. No submissions in the recusal application. Yes, please.
Yeah. All right, I'm going to stand this matter down. Just need to do one postponement. I thought I'll carry on with my part head after this matter. I don't foresee myself proceeding with it if an argument just for legal representation can take the time that it took. So it means the 342 also, it's going to be lengthier. So can I just excuse my other parties in my part head? So this matter will stand down.
There's a copy, Your Worship.
Where's the court order?
I'll resume at 15:15, meaning that I'm giving you just 10 minutes to stretch for me to do the postponement.
Thank you. Thank you. Your Worship, I'd just like to respond on just a few issues that were raised by my learned colleague in his address. I've just lost my track of thought. Oh, yes, the issues are with regard to one is with regard to the evidence that the state claims or alleges will be led, and the counsel is a witness that the state would like to call. This is with regard to the Article 39.2. Clearly, my colleague didn't understand what the state meant by having to call him as a witness. I would not like to get into the merits of the matter and also give evidence, but only mention that the evidence at the disposal of the state is that my colleague was at one point interpreting and explaining the application of the articles of the statutes of Safa. And there is a recording to that effect, which the state is still busy getting it transcribed, which would necessitate my colleague to testify for the state on, Your Worship. Now, the other point that was raised was that in the disclosure that they received, there is no statements by Mr. Sidibe, and I can't remember who was the other person, but they forget that I have raised in this submissions that upon receiving the representations by accused 2 and 4, it became necessary that further investigations be made based on the allegations and the claims that were made by accused 2 and 4 in their representations. And those further investigations revealed further information from those witnesses. One of the witnesses is Mr. Sidibe. And the other evidence is that of the council that relates to that 2015 Congress, wherein my colleague was explaining the application of the provisions. It's not about my colleague coming to the witness stand and giving opinion about how section Article 39.2 applies, but either confirming to this court that yes, this is what I said during the 2015 Congress. We have the recording, and that recording is where my colleague was explaining how Article 39.2 applies, and it is for him to come and confirm or deny, not to make any opinion, legal opinion, or any opinion of any kind, Your Worship. So that is, those are the points on which I wanted to clarify to God. Further, Your Worship, my colleague came here and said a lot about the internal workings of Safa for someone who's not working for Safa, or who stopped working for Safa a long time ago, Your Worship. He definitely knows a lot about what's going on in Safa. My colleague does not, again, respond to the issues about him, particularly his appearance in this court on the 5th of December, and the judgment being given on the same day at the High Court, where he was briefed to appear on behalf of the complainant. He does not address that issue. He totally tiptoes around that issue and says a lot of issues that are irrelevant for this hearing. He delves into the merits of the case, which I believe was uncalled for and not necessary. We are not here about the merits of the case, but about the issues, the criminal issues that are being raised by this application. Furthermore, Your Worship, a letter by the CEO, the current CEO, Ms. Munyipao, does not really serve a purpose. Does one need a permission by any other person to lay a charge, a criminal charge, against a perpetrator? That cannot be. If the argument is that Mr. Moga was disgruntled at the time, and therefore he could not lay a charge on behalf of Safa, and I had the insinuation, I'm just not sure, the insinuation is that he was no longer a member, but from the evidence that we have, he was still a member of Safa. He may have been suspended, but he was still a member of Safa NEC. Now, if the argument is he could not lay a charge because he was no longer a member, how then can the current CEO come and say Safa has not authorized Mr. Moga to act on behalf of it, when this matter or these charges were laid in 2020 when the CEO was not part of Safa? The same argument can be used against the author of that letter. However, it's neither here nor there. The fact remains, no one needs a written permission by anyone to open a criminal case where an offense is committed. My colleague referred to a code of conduct, not the code of conduct, but what he referred to as part of the articles of statutes of Safa, that it is a misconduct to take Safa to court. In this instance, no one is taking Safa to court. And that is understandable for as long as we're not talking about criminal offenses. Yes, if a member of NEC has to take Safa to court, it's their internal issues that can be decided upon by their own statutes. But then if one steals from Safa, if one defrauds Safa, absolutely no one needs any permission by any article of any association to go and lay a criminal charge or register a criminal complaint against any perpetrator. In this instance, we have the CEO, the CFO, the president, who are not necessarily interested in opening a case against anyone who perpetrates an offense against Safa. I'm talking about back in the year 2020, when Mr. Moga realized that offenses were committed against Safa. Did anyone raise it? Did anyone decide, let me, for example, as the CEO, as the CFO, go and open a case against a person who's been fingered as having defrauded Safa, as having stolen from Safa? No one did that. It only took Mr. Moga, an ordinary member of the NEC, to do such. Did he commit wrong? No. He was well within his rights. Safa is a public body, as I stated earlier. It's a private entity which serves public interests. Its aims and objectives are to serve the public at large. Yet in its registration, it's registered as a private entity. But in its dealings with for example, the SARS, it's referred to as a public benefit organization. And it's indeed a public benefit organization because its role is to see to it that it works for and on behalf of the whole public of the Republic of South Africa. I still reiterate that Safa is the complainant. It can only act through its own officers, accounting officers, and its members. But then if the members and officers are the same perpetrators, those who are not perpetrators can take the responsibility and lay the charges. Now, in as far as Section 35 is concerned, Your Worship, here we're not talking about the taking a right away from the accused to be represented. Firstly, every right is limited. No right is absolute. And in this instance, the accused rights are not being limited to the extent that they don't have representation. If there is a conflict, of course, that right will be limited to an extent that a counsel or a representative who is part of that conflict would have to step aside and let the accused obtain equally competent legal representation and continue with the matter. It doesn't mean if the counsel were to be ordered to recuse himself, the accused would now be expected to go on trial without any legal representation. He would still have a right to appoint any other legal representative who is not conflicted, who is not biased, or who is not by the reason of proximity to both parties prejudiced. And that's how it works, Your Worship. In as far as jurisdiction is concerned, Your Worship, we deal with issues of recusal on a regular basis in this court. I've never had anyone raising the issue that before any matter should be, or any person should be recused, it must go to the Constitutional Court or to the High Court for the issues of constitutionality to be decided upon, Your Worship. That cannot be. And that is my address, Your Worship, as the purpose.
Thank you. All right, I'll deal with the first point in limine. Make a ruling on this point in limine that pertains to illegal representation by Advocate Norman Arends. I must say that the right to legal representation, it is jealously guided and also guarded by the Constitution, which is governed by Section 35, which states that every accused person appearing before a court of law has a right to legal representation of his choice. So in this instance, the accused person, I'm referring to accused number 1 and 3, have elected to appoint the instructing attorney who, as a result, instructed a counsel, which is the counsel's name that is in issue at this moment. I must say that before I proceed with everything, there's no application for locus standi before this court. So I'm just dealing with the issue of legal representation. Now, when it comes to the legal profession, it is known that there are bodies that regulate how the profession should operate. This court states that the LPC is one of those professions. The Bar Councils, it's another platform which this aspect can be raised. Why I'm saying so? It's because this court cannot deal with an aspect of a constitutional nature. It has to go to the High Court, and it can escalate from the High Court until to the highest court, which is the Constitutional Court. Because this is one of the rights that promotes a fair trial. I agree with the state that we're not taking away their right, but they can choose another attorney. But I would say that if there is conflict, Advocate and that conflict gets clarified, or it becomes visible during the trial, it's going to have negative impact on the finalization of the case, because another counsel will want to get the recordings. And furthermore, it will have a bad reflection on your career, because as we take instructions as attorneys or as legal professionals, we ensure that we avoid the conflict of interest. Now, the state says that Safa is one of the complainants. Sitting as a court today, I don't know what is contained in the state docket, but I cannot take away at this moment the right of the accused to legal representation. My hands are tied because I have not seen the conflict itself. I'm speaking about something that is still in the box, that when the box is open, I'll be able to see. At this moment, I cannot say if there is a conflict or not. But this court says that if there is a conflict, state, nothing stops you from lodging an application with the legal body that is responsible for the advocate or any party involved in these proceedings, because that will tantamount to delay the matter. This court also, I'm referring to the legal body. Why? This court is not equipped with methods of investigating such a conflict, but the legal body is equipped. It can deal with it, and it can make a conclusion, and that conclusion will help the person who have applied to motivate that to the court. Not that I did not pay attention, state, to the application that you brought. More especially, it raises questions to this court. The case of Safa, where advocate has proceeded, being the legal representation up to the finalization of that case. So I'm saying to the state at this moment, I'm of the opinion, recusals that I have dealt with, it deals with the presiding officer herself or himself. That one I have jurisdiction. I think we have seen where the former president wanted the one of the councils not to deal with the matter. I'm citing that case law because that application also failed. But that was not the regional court level. It was at the high court level. So when I'm saying that if I have to tamper with a right that is governed by the Constitution, as I'm a creature of statute, I would say in terms of the constitutional law, I don't have jurisdiction to deal with that aspect. It has to start in the High Court. So in that instant, by so saying, I would say that I'm going to allow the advocate to present accused 1 and 3, but I'm warning you, advocate, you reconsider it if there is a conflict. I don't say reconsider just. If you see that there will be a conflict, the state will take that application, and you must be aware that it's going to affect the finalization of this matter.
As the court pleases.
Thank you.
Yes, my lady, I obviously heed those words of caution. So it would help that if my colleague is serious about this matter, that he refers the complaint, and especially if your ladyship is minded to grant the relief that we seek in the 342A, there would be enough time for that matter to be ventilated, because obviously the relief that we seek doesn't mean that the case against the accused are dismissed. It can be brought back, and presumably it will take a while, but the LPC or the Bar Council can deal with this matter, my lady.
Thank you.
Thank you.
Right.
As a corpus, Your Worship. Your Worship, the state trusts the wisdom of this court in its judgment and the reasons for the judgment. It will at this stage not pursue this matter any further, but save where a conflict rears its head, if it were to happen in future, the state reserves its right to continue. For a moment, we do not want to delay this matter any further and or give any reasons for the state to be held in to be holding this matter unreasonably longer than it should be, Your Worship. For the moment, the state is ready to proceed with the second application.
Thank you.
As a corpus.
All right, we can move now to the second application, and I believe that the second application was initially brought by accused 1 and 3. In chambers today, I've noticed that accused number 2 and 4 joined the same train of the application in terms of section 342, capital A. So I'm moving to the second application, which is section 342, capital A. The applicant, you can move your application, Advocate Arets.
Thank you, my lady. My lady, you have hard copies of the notice of application?
Yes, I have the notice. I've printed.
I know you prefer hard copies, so we do have a nicely bounded.
All right, you can provide. Thank you.
Okay, it's this. Huh? Thank you. And then we. And this. It's, you got a copy of that? We'll also provide you with a copy of our short heads of argument.
Okay.
And then these applications for High Court. And this is only, my lady, in the event that I do, if these are the High Court applications. Don't be daunted by the thickness of it. I might refer to 1 or 2 paragraphs in it, my lady.
It's okay.
It's only because it's under oath and we incorporate it into the application.
Okay.
My lady, notice was given on the 4th of December, the day before we last appeared here on the 5th, by my instructing attorney, and that's Annexure DJ6 to the application, that a section 342 application would be brought today. Subsequently, your ladyship will recall there were issues around the docket, and we got the docket late on I think it was Thursday late, and of course it's quite a formidable bundle of documents, work through it, and eventually we got this application to our learned colleague and to yourself, I think during the course of yesterday morning, and we hope that you had an opportunity of going through it. Again, I'm only going to highlight, my lady, certain aspects of it. The main relief that we seek, my lady, is that the matter be struck from the roll, and that the prosecution of this case not be resumed or instituted de novo without the written instruction of the NDPP or the Provincial Director of Public Prosecutions. we also ask in the alternative for costs as a result of the unreasonable delay, but it's not something that I'm strenuously pushing for, my lady. And alternatively, we also ask that the matter be removed from the roll because a complaint has already been lodged with the DPCI judge in relation to the conduct of the investigating officer in this case, arising from the search and seizure which took place on the 8th of March this year, and also a complaint against my learned friend, the prosecutor. These matters will take time, and we expect, and submit that any reasonable person would expect that it will result inevitably in a delay. So the basis of this application is, so this is a bit unusual, my lady. This is not one of those cases where your ladyship is an expert in this area, where accused come before you time after time after time, and the case is postponed, and you want to know what happened, and then there's systemic issues about the system, and they weren't brought to court or whatever. And it's quite possible, like for example, in the well-known Daliniebo case, it took 8 years before he was prosecuted. So this is not one of those cases, my lady, where that is the case. In fact, this is only the second appearance. They had one appearance, and if the matter had to be postponed last week in the ordinary course, they would probably have been directed to appear again next year. So this is not one of those cases. This case does, however, concern the substance of what Section 342A is about. Is that, and this is again enshrined in our Constitution, that you're entitled to a speedy trial, and that your matter be concluded as soon as possible, without delay. We know some of the allegations that are out there in the public and that have been made publicly, outside of the two charges that the accused face, the Grit and Badger contracts. In this case, those, and I've referred to them earlier as these disgruntled ex-officials and employees, for them it was a case that throw as much mud and hope that some sticks. And unfortunately, some of our media have bought into that narrative. So, for example, and it's in our papers. It's before you under oath, and your ladyship would note immediately that there's no opposing affidavit before you. For example, in relation to the rape allegations, we've got before you a letter from the National Commission of Police in 2021 that the investigation will not be pursued, and Dr. Jordaan may regard the matter as finalized. That was in 2021. We're now in 2024, heading into 2025. Somehow these allegations are still swirling around. So the basis for this application is these complaints that have been lodged against the investigating officer and the prosecutor. And then also there are two cases that are pending in the High Court in Gauteng. The first matter is case number 2024-035-799, which was issued on the 4th of April, and that relates to the search and seizure warrants that was issued by Your Ladyship's colleague Kotze, the magistrate.
Mr. Koen.
Sorry, Mr. Koen.
Petrus Koen.
Sorry, Koen. Mr. Koen, apologies. And I'm not going to repeat the allegations that's in the papers in that case. One of them being that the investigating officer failed in his duty to disclose certain relevant matter to Magistrate Mr. Koen when he issued the search and seizure warrants. Now, Your Ladyship is more than experienced to know that these search and seizure warrants are quite invasive. They are granted almost always ex parte. In other words, the party applying for it is the only party before the magistrate or the judge, and that is why the law requires the person asking for these warrants to act in the utmost good faith, which means that you must disclose, you're under a duty, a legal duty, to disclose to that magistrate or judge matter that's even adverse to your case. You're under a duty to do that. And our investigating officer in this case failed to do so, and that's one of the bases on which there is an application before the High Court to set aside the warrants. We also know, because it is now common cause, the investigating officer, I don't think the Minister of Police is participating actively in the NPA. They accept that on the day that the Safa CEO, Ms. Monyepao, and Mr. Growney, who is Schloyer, who is accused number 3 in this case, on the day that the raid took place, they requested from the police the affidavits that support these warrants. They weren't there. They were only made available subsequently after. Sorry,
3 days.
Yeah, they were only provided some 2 weeks after the search and seizure. And I'm not going to go through what once my attorney and other counsel involved in the matter, once they analyzed these affidavits, they saw a number of defects in them, and our submission is that, and of course Your Ladyship is not deciding the matter, that there are excellent prospects that the relief sought will be granted. Now, what is the status of that matter? It's common cause that the state respondents, the police, filed more than 3 months late their answering affidavit, so there's still an application for condonation. A replying affidavit has been filed, so the pleadings are closed. I understand that the applicants have filed heads of argument and they await the respondents' heads of argument. But the point is that this matter is only likely to be heard in the 3rd or 4th term of next year, given the congested court roll that Your Ladyship will take note of in Gauteng. So inevitably that's going to result in a delay. And the submission is that with respect that this prosecution cannot proceed until that matter is decided. Of course, it may even go on appeal either way, because if the court does find that the search and seizure was conducted unlawfully, it impacts on this trial, and it impacts on the conduct, negatively on the conduct of the investigating officer. The second matter is the application that was brought on the 14th of November. In fact, it was initially brought on the 11th of November, but there were some service problems, and the matter was then only brought or set down for hearing on an urgent basis on the 14th. But the accused, 1 and 3, were then arrested on the 13th of November. Now, what is significant, my lady, is that, and again, this is uncontested evidence before you, is that on the 7th of November, the investigating officer, Captain Magano, phones my instructing attorney and the attorney for accused 1 and 3 and says, I'm coming to arrest your clients, or I want to arrest them, something to that effect. And my attorney says, look, you don't need to do that. I'll bring them to your office. Like we've all done at some point in our careers, to save the ignominy and embarrassment of being arrested in public. So that was on the 7th of November. The application was, as I said, there was an aborted attempt to bring it on the 11th. So with respect, the investigating officer was aware that this application was being brought. Instead, he preempts that by then effecting the arrest of accused 1 and 3 on the 13th, which to a large extent then cut the accused 1 and 3 off below the knees, because they couldn't proceed with their urgent application set down for the 14th of November. And the relief sought in that matter, my lady, is that the warrant issued for the arrest be suspended pending the outcome of that review application now under the first case 035-799, and to interdict the state respondents from executing these warrants, which were communicated on the 7th of November 2024 with immediate effect. Then the third ground, my lady, is the complaint lodged with a DPCI judge, and on the 15th of March, which is just about a week after the raid on Safa House, accused number 3, Mr. Sloyo, lodged a complaint, which he sets out in his affidavit, my lady, and again, I'm not going to repeat what he says there. It is common cause. What happened, it is not opposed, it is not contested. And as will appear from the uncontested, unopposed affidavit, my lady, in support of the complaint, the conduct of the investigating officer and the police was deplorable and brought the administration of justice into disrepute. Subsequently, and again, this is a fact, this is not evidence, my lady, it's a fact notorious enough for your ladyship to be aware of. A judge had to be appointed to head the DPCI complaint directorate, and that appointment only occurred recently, so there was a huge backlog, and even though the complaint was lodged in March, on a week after the raid, both accused were only interviewed for more than 2 hours. I think that was last week in your offices, in my attorney's offices. So that complaint also, my lady, will take time to be completed. No doubt the investigating officer and other members of the walks who were there, they're going to be interviewed and so on, and that may take time. And again, my lady, in our short heads, there are references in to our affidavit. If I may just refer you to paragraph 45.1 to 45.5.
Paragraph?
Of the first application, lady.
Paragraph?
Sorry?
Which paragraph?
45.1 to 45.4. Is it that one? In the affidavit. Sorry, my lady, it's in the affidavit that it's in the affidavit on page 22 attached to this application today. Sorry. But it replicates what's in the affidavit before the High Court. At paragraph 45, the details of the search and seizure conducted at Safa House were unlawful, as the warrants of search and seizure were unlawfully obtained. This is currently the subject of a High Court application. The purpose of the complaint is to request the investigation of the unlawfulness of the conduct of the DPCI members. First, in inviting the media to Safa's offices during the search and seizure. 2, the reasons why the DPCI members did not furnish Mr. Schloyer and the Safa CO with copies of the supporting affidavit which was used during the ex parte application of both warrants. 3, the delays in providing the requested affidavits even when our attorneys had requested same. The fact that in their media release the DPCI disclosed publicly the known title of the president of Safa during an ongoing and alleged investigation. And 4th, the fact that this is accused number 1, the fact that his name and identity numbers appear on the face of both search and seizure warrants, and yet his office, that's the president of Safa, and he himself and any equipment were not searched or even spoken about during the raid. And the exclusion of the instructing attorneys who were already known to the DPCI investigators prior to the raid. So the submission is, my lady, on behalf of the accused, that the raid on Safa was ill-founded, malicious, and without justifiable cause. The police officials conducted themselves procedurally unfairly, unreasonably, and unlawfully. So those are our 3 pillars, my lady. And we submit that it is beyond doubt, beyond debate, that inevitably there is going to be a delay. A delay not caused by the accused, but a delay caused by the conduct of the investigating officer and his other officers who were involved in the unlawful raid. Now, my lady, I then go on to make the legal submissions, and the leading authority, your ladyship will know, is the case of Sanderson versus Attorney General Eastern Cape, 1998 case, judgment of Justice Kriegler, as he then was. Although it dealt with the interim constitution, Sanderson has been referred to and approved in many cases subsequently. And as is submitted, my lady, this is not your usual delay. This is somewhat different, but because we're dealing with the pre-trial constitutional rights of the accused, we submit that your ladyship will take cognizance of that and rule that the delays have been unreasonable. Your ladyship knows from the debate on the recusal that this is indeed a matter that predates 2020, and we know that Mr. Muka, and it is just unfair, undignified, and unjustified for these accused to be called back to this court to put in formal appearances only for their bail to be extended, and to be held out in the public as accused persons when they know their matter is not going to be heard and it's not going to be finalized. It has a serious impact on their dignity, my lady. There's already been calls for the president to step aside, like Safa is the ANC, must step aside, like Mr. Kodwa did in this court, to his credit, my lady. But there's no provision for that. But there is pressure, and it's unfair to for that to persist when there's no prospect of this matter being concluded in the foreseeable future. So your ladyship knows from Sanderson and the other cases that your ladyship is required to consider the factors that are set out in paragraphs 2A to H of section 342 capital A, and your ladyship will know from the case law that your ladyship has a discretion, and that your ladyship is required to make a value judgment. There's no factor that's decisive. If I may just refer to Sanderson, my lady. need some connectivity, manager. I think your ladyship has the citation of Sanderson.
I have. Let
Yeah.
me just give you the citation.
In the
Sanderson.
opening paragraph, sorry, my
You
lady.
have the citation.
The citation, my lady, is.
Sanderson versus
Um,
Attorney General.
Do you want the Juta or the Butterwoods?
No, anyhow, it's okay.
The Juta is 1998 brackets 2 SA 38 Constitutional Court, and Butterwoods is 1997 brackets 12 BCLR 1675 Constitutional Court, and it's a judgment, unanimous judgment of Justice Krichler. And he says in the opening paragraph, which gives you an idea of what the case is about, that the appeal concerns Section 25(3)(a) of the Interim Constitution, which provides that every accused shall have the right to a fair trial, which shall include the right to a public trial before an ordinary court, and this is the phrase we concern, within a reasonable time after having been charged. Then he says more specifically, it relates to the meaning of the two phrases with quote-unquote within a reasonable time and quote after having been charged at the end of that paragraph, and the effect in the light of the facts of the case. So then he deals with the facts. Yeah, at paragraph 20, Justice Krichler writes, the next step is to examine the phrase quote-unquote within a reasonable time in seeking to understand the scope and effect of the phrase in the context of the section. A useful starting point is to establish why the right to a trial within a reasonable time was included as one of the specifically enumerated elements of a fair trial. Then at paragraph 21, he says the right to a trial in a reasonable time is expressly cast as an incident of the right to a fair trial. Yeah. And this is the ratio of the case, Marie. Paragraph 22. Despite the persuasiveness of some other argument that he dealt with, it appears to me that all three kinds of interest should be regarded as being protected under the rubric of Section 25(3)(a). There are two reasons. First, this court has taken a broad and open-ended approach to the scope of Section 25(3). Writing for the court in S versus Zuma and others, Kentridge AJ affirmed that, and I quote, the right to a fair trial conferred by that provision is broader than the list of specific rights set out in paragraphs A to J of the subsection. It embraces a concept of substantive fairness, which is not to be equated with what might have passed muster in our criminal courts before the Constitution came into force. marking a significant break from the common law past, Kentridge AJ suggests that criminal trials should be conducted in accordance with open-ended notions of basic fairness and justice. Now, and this is important for the purposes of my clients. They're still my clients. When he says, I will suggest in a moment why the fair trial protection of the accused extends to non-trial related prejudice. But my point here is simply that a narrow textual approach to 25.3 is likely to miss important features of this provision. Then he deals with the nature of the criminal justice system. Then he goes on to deal with social prejudice. At paragraph 24, this is important, Banadi. The right to a trial within a reasonable time also seeks to render the criminal justice system more coherent and fair by mitigating the tension between the presumption of innocence and the publicity of trial. It acknowledges that the accused, although presumed innocent, is nevertheless, quote-unquote, punished, and in some cases, such as pretrial incarceration, the punishment is severe. The response of the Constitution is a pragmatic one. The trial must be within a reasonable time. It makes sense, then, that a substantively fair trial along the lines contemplated by Kentridge AJ in S v. Zuma would include a provision that minimized the non-trial related prejudice suffered by an accused. And those are with respect, those are those two pending applications in the High Court and also the DPCI investigation. The right in section 25.3, insofar as it protects non-trial related interests, is perfectly situated in the provision and is fundamental to the fairness of the trial. Then, as far as the test for what is reasonable, my lady, at paragraph 30, the test for establishing whether the time allowed to lapse was reasonable should not be unduly stratified or preordained. So, and there's reference to later on in the other leading case to Daliniebo, even 8 years. So you can't say after a year, 2 years, 8 years. That's not helpful, my lady. Then at paragraph 31 he says, let me turn now to a consideration of the most important factors bearing on the inquiry. The first is the nature of the prejudice suffered by the accused. Ordinarily, the more serious the prejudice, on a continuum from incarceration through restrictive bail conditions and trial prejudice to mild forms of anxiety, the shorter must be the period within which the accused is tried. Awaiting trial prisoners in particular must be the beneficiaries of the right in section 25.3. But as I've acknowledged and I accept that this case is somewhat different. Then the learned judge says at paragraph 32, an important issue related to prejudice should be clarified. It is the relevance of the accused's desire that the trial be expedited. And then the learned judge makes the point which I absolutely accept, is that an accused can't rely on the 35.3 rights if the accused is a primary agent of the delay that causes the delay, like in the case of Daliniebo. Then the second factor the judge deals with is the nature of the case. And like your ladyship would do in this case. Instead, judges must bring their own experiences to bear in determining whether a delay seems over lengthy. If a person has been charged very early in a complex case that has been inadequately prepared and there is no compelling reason for this, a court should not allow the complexity of the case to justify an over-lengthy delay. Even cases which appear simple may involve factors which justify delay. The personal circumstances and nature of the witnesses should be considered. At paragraph 36, having isolated some of the relevant considerations, how are they assimilated in determining whether or not a lapse of time is reasonable? The qualifier reasonableness requires a value judgment. In making that judgment, the courts must be constantly mindful of the profound social interest in bringing a person charged with a criminal offence to trial and resolving the liability of the accused, particularly when the applicant seeks a permanent stay of prosecution. This interest will be large. So that's not what we are asking in this case, my lady. We've made out the case or our clients have made out the case in the matters before the High Court in Johannesburg. We've made out the case here in this application that the prospects of a successful prosecution are slim, and that, but I accept that at this stage it would be premature to ask for a stay of execution. Oh, sorry, prosecution. Prosecution, my lady. What we ask for is remove the matter from the roll. I'm not quite sure actually, my lady, what happens with the bail. Does the bail stay in place or not? Are you still...
When the matter is removed from the roll, the matter is not on the roll. The depositor of the bail will be refunded. The bail money.
Bail will be refunded.
Yes.
Thank you, my lady. Because we're also asking that if the prosecution is reinstated, then it must be reinstated by the National Director of Public Prosecutions or the Provincial Director of Public Prosecutions. Then, my lady, the other important case is which is much more recent. Is the case of Ramabele.
Okay.
Ramabele V.S. and Msimango V.S. The citation, my lady, Juta is 2020 (2 SACR 604 Constitutional Court, and Butterworth's is 2020 (11 BCLR 1312 CC. in the matter between Sediso Ramapele versus the state and MacDonald Msimango and others versus the state. It's a unanimous judgment of Justice Mashlankla, and it also concerns fair trial rights, postponement for legal representation of choice, judicial bias, unreasonable delays. And I'll just quickly refer to some of the relevant paragraphs for the purposes of our argument, my lady. The court deals from paragraph 54 onwards, my lady, with section 342A. At paragraph 56, the overarching aim of section 342A is to, quote, provide courts with a statutory mechanism to avoid unreasonable delays in the finalization of criminal proceedings. Section 342A empowers a court to examine the reasons for the delay. In order to ascertain whether the delay is reasonable or not, courts consider an array of factors as stipulated in section 342A brackets 2. In the event the court finds that the delay is unreasonable, section 342A brackets 3 provides an open list of potential remedies. At paragraph 57, it has been said that section 342A is, quote, the vehicle for giving practical application to the section 35 3D right to have a trial begin and conclude without unreasonable delay. And this is important with respect, my lady. Therefore, when considering section 342A, one must be mindful of section 35 3D of the Constitution, which entrenches an accused's right, constitutional right, to an expeditious trial. And then the court confirms my submission, my lady, at paragraph 58. The seminal case on unreasonable delays in criminal proceedings before section 342A came into operation is Sanderson. At 61, a proper reading of section 342A as a whole reveals that the section requires an investigation into the reasonableness of the delay. Courts have grappled with this provision and held that an inquiry is necessary in order to sufficiently consider the reasonableness of the delay. And then at 65, the court refers to Dalin-Yebo, where the Supreme Court of Appeal reiterated that given the circumstances of that case, since the delay in the appellant's prosecution was caused largely by appellant's own problematic behavior, there was no delay in the impeding on fair trial rights. And at 66, therefore, what one can derive from this is that where the delay is caused by the conduct of the accused, the delay cannot per se serve as a basis for the court to decide that the subsequent behavior was unfair. Okay, thank you. So those are the leading authorities, my lady. And to bring it in line with our submissions, my lady, we refer to the case, and I'm not going to the reference is there, Zanner, Z-A-N-N-E-R, v. DPP Joburg, 2006-2, SACR 45, Supreme Court of Appeal at paragraph 15. Whether the delay caused prejudice to the accused can be decisive. There's also authority, my lady, in paragraph 24. I'm now going back to my heads of argument. Paragraph 24, a temporary stay of prosecution was granted in Austin v. Minister of Justice and others, 2018 to SACR 49 in the Eastern Cape. And that, my lady, was pending. That's interesting. Pending the confirmation by the Constitutional Court of the order in Prince versus Minister of Justice and others, where unconstitutionality was found in a similar case. That case, your ladyship will know, was dealing with marijuana, and Mr. Prince, who's also a colleague, lawyer, he got into a spot of bother there. But what happened? Because this case is pending in the Con Court, the other case, there was a temporary stay because we're waiting for the outcome in the Constitutional Court. Because there's no prejudice to the state, and I submit with respect, there's no prejudice here to the state if the matter is removed from the roll. We also know that once a matter has been struck from the roll under this section, only the DPP, not the state prosecutor, can issue a written instruction that proceedings be resumed or instituted de novo. And the authority for that, my lady, is Naidu versus NDPP, 2005, 1 SACR 349 SCA at paragraphs 38 and 44, and your ladyship as that reference at paragraph 25. Section 342 3C does not require a formal inquiry to be held or that a formal finding be made. It is sufficient that the presiding officer inquire into the reasons for the request for a further postponement and conclude that a further postponement would lead to injustice. Section 342A merely provides guidelines with reference to the factors a court should take into account when considering whether to refuse a postponement. That's S versus Van Heystien, 2004-2 SACR 478 brackets C. So in conclusion, my lady, we submit that it is inevitable that the two High Court matters, and coupled with the complaint that's been lodged against the conduct of the investigating officer, would result in the prosecution of this matter being delayed for an indeterminate period and result in much uncertainty. And we submit as a result, it's hugely prejudicial to the accused, and less so to the state. And we submit this is a good ground for your ladyship to remove the matter from the roll. I'll just end off my instructing attorney just makes these points, my lady, which is important. He says the accused cannot exercise their pre-trial rights at this stage because of those pending matters. Firstly, they cannot request further particulars. Secondly, they cannot make representations. Thirdly, they cannot decide on a plea. Yeah. So, my lady, those are our submissions, my lady. And we'd ask, the main relief we ask for is that the matter be removed from the roll.
Mr. Malibati, are you ready to address this application, or you want an adjournment? See that we went, it's 5 to 2 now. Are you ready?
May I just inquire, Your Worship, the adjournment as to short adjournment or adjournment for the day?
No, not for the day.
For the day.
Not for the day.
Not for the day.
Yeah.
Yeah.
I just wanted to find out, are you ready to proceed? I'll allow you to do so. If not, then I'll have to adjourn. And just take a short adjournment,
Yes.
because I went
I
way past the lunchtime.
I believe Mr. Ndebele still has to address the court before
Yes, yeah.
I do.
Okay, yeah.
Yes.
Yeah.
But I would suggest we take a break at this stage, Your Worship.
Yeah, let's take a break. Mr. Ndebele, you'll start, when we resume, you'll be the first one.
Yes, Your Worship. There's a court
All
case.
right. Let's see, colleagues, it's 5 to 2. How long do you need? We don't normally take lunch at this
Really,
point,
for your ladyship,
because
has
I
had a long
finish
day.
earlier.
I would be selfish and want a shorter break, because I also have a plane to catch, my lady. So
Okay.
maybe 15-20 minutes.
15 minutes.
But it's up to you
All
and my
right.
colleague.
Is everybody comfortable with the 15 minutes adjournment? Meaning that I'll walk in at 10 past 2.
Perhaps 20 minutes,
20 minutes,
Yeah.
quarter past 2?
quarter past 2, yes.
All right.
There are things we can reach a consensus on, my lady. 20 minutes sounds good.
All right. Thank you. All right. Court adjourns for now for that lunch break. Thank you.
God pleases Your Worship, matter to resume after a refreshment break. The parties are still making their submissions. The counsel for accused 1 and 3 has made submissions. It is now the turn for the representative for accused 2 and 4 to continue, Your Worship. As the court pleases, the appearances are still as before.
Thank
As the
you,
court
sir.
pleases.
Mr. Ndebele, sir, it's your turn.
As the court pleases. Your Worship, in light of the fact that the second and fourth applicant entered into the fray of this 342A application late, I appreciate that the court has not had an opportunity to read the submissions by the second and fourth applicant. What I will do, Your Worship, is read the submissions, not all of them, Your Worship. I will take the court through so that the court follows, in essence, the basis upon which the second and fourth applicants have joined the 342A application. Your Worship, if I may proceed, the second and fourth applicant are moving an application in terms of Section 342A of the Criminal Procedure Act. The second and fourth applicants seek in the main for an order in terms of Section 342 capital A, sub 3, sub C. Your Worship, Section 342A reads, a court before which criminal proceedings are pending shall investigate any delay in the completion of proceedings which appears to the court to be unreasonable and which could cause substantial prejudice to the prosecution, the accused, or his or her legal advisor, the state, or a witness. Subsection 3C, Your Worship, reads, where the accused has not yet pleaded to the charge, that the case be struck off the roll and the prosecution not be resumed or instituted de novo without the written instruction of the Attorney General. The Attorney General, Your Worship, could be the Director of Public Prosecutions for the South Gauteng Local Division, alternatively the National Director of Public Prosecutions herself. Your Worship, it is tried that role players in the criminal justice system must be vigilant and ensure undue prejudice and delays in criminal proceedings are curbed, as a failure to protect a person's constitutionally enshrined right to a fair trial will lead to society mistrusting the criminal justice system. A.L. Schneider, in the book The Right to a Fair Trial, contends that undue delay in the administration of the criminal justice system impairs the ability of an accused to refute the charges brought against him or her. The right to a speedy trial, or the constitutional imperative to avoid unreasonable delays in trials, was considered by the Constitutional Court in Sanderson versus Attorney General, Eastern Cape. In this matter, the court held that the three most important factors to be considered are: 1, the nature of the prejudice suffered; 2, the nature of the case; and 3, the systematic delay. Relative to the matter at hand, to which the second and fourth applicants are charged with, is Feedman Development Pty Limited and another versus Attorney General of KwaZulu-Natal, wherein the relevant factors were identified as follows: 1, the length of the delay from the alleged commission of the crime to the commencement of the trial; 2, the reasons for the delay, among which would be the availability or non-availability of witnesses, the degree of complexity of the case, its inherent requirements, the difficulties encountered in the investigation of the case, the marshalling of the evidence and tracing of witnesses, and the preparation of the case for trial; and 3, any prejudice which the accused suffered or were likely to suffer as a result of the delay. Section 35, subsection 3 of the Constitution of the Republic of South Africa states that every accused person has the right to a fair trial, which includes D, the right to have a trial begin and concluded without unreasonable delay. This is a non-derogable right. To this end, Section 35(3)(d) of the Constitution obliges the court in which criminal proceedings are pending to investigate any delays which appear to be unreasonable. Section 38 of the Constitution states that everyone, especially those acting in their own interest, is entitled to approach a competent court alleging that a right in the Bill of Rights has been infringed or threatened, and the court may grant appropriate relief, including a declaration of rights. The Constitution is a starting point to emphasize the importance of a trial to begin and conclude expeditiously. In order to stay in line with the ethos of the Constitution, which is to afford accused persons the right to a fair trial, legislation was enacted to ensure that unreasonable delays do not go unwarranted. It must be remembered that this happens in the understanding of the inherent prejudice to an accused in facing a never-ending trial and a cloud of allegations. As could be appreciated, this has serious consequences to a person's liberty and participating in normal life, such as gaining employment or trade and being accepted as a member of a community. It is also important to highlight the kind of prejudice that is suffered by the second and fourth applicant in this matter. The courts have also recognized non-trial related prejudice. As is the case in this matter, the charges arise out of factionalism within and outside the South African Football Association, in particular, persons holding gripes with the first applicant, namely Dr. Danny Jordaan. The second and fourth applicant have since been subjected to public humiliation, prejudice, and public condemnation. Section 342A of the CPA amplifies and affirms Section 35 of the Constitution and gives the court the power to grant remedies that will deter any prejudice and delays. Your Worship, for the sake of time, I am going to skip reading paragraph 12 and 13. I'll proceed on page 6. It is a tried principle of the administration of justice that justice delayed is justice denied. Delay devalues judgments, creates anxiety in litigants, and results in loss or deterioration of evidence upon which rights are to be determined, and cause general prejudice and undermines the integrity of the administration of justice. Delays signal a failure of justice and subjects the court system to public criticism and loss of confidence in its fairness and utility as a public institution. Section 342A of the CPA provides that a court before which criminal proceedings are pending shall investigate any delay in the completion of proceedings which appears to the court to be unreasonable and which could cause substantial prejudice to the prosecution, the accused or his or her legal advisor, the state, or witnesses, as I've read, Your Worship, from Section 342 as it is written, Your Worship, in the CPA. Your Worship, I'm going to move on to page 7, paragraph 18. The second applicant has been trying to undertake various business activities for survival in the current economic climate. These criminal charges against him have had a very serious impact in his ability to focus on his endeavors. It is on that basis that he finds it extremely unfair that his life is being destroyed by the state for nefarious reasons. It is unfair for the second and fourth applicant to have to suffer prejudice and social stigma as a result of undue prejudice by the state. More importantly, the state's conduct has seriously violated the second and fourth applicants' rights to a fair trial as contained in Section 35(3) of the Constitution. Your Worship, in order to assist the court in exercising its judicial discretion and arriving at a valid judgment, I beg leave for the court to allow me to provide a brief background into the facts of the matter. It is not the intention to have this court make any pronouncement on the merits. However, Your Worship, the facts are important for the court to arrive at its valid judgment. The second applicant is a director of the fourth applicant herein, Grid Communication Pty Limited. The allegations against the second and fourth applicants relate to commercial service level agreements between the fourth applicant and the South African Football Association, Safa. The facts of this matter clearly demonstrate that the second and fourth applicants cannot be found wanting on any allegations of impropriety. The fourth applicant is a communication service provider. The company provides reputation management, communication, and media relations advisory to various clients within the South African market. Since 2013, the fourth applicant has been contracted by numerous organizations to provide media relations and communication services. One of the fourth applicant's clients was Safa, in respect of which these unfounded allegations relate. Having considered the charge sheet and contents of the docket, it is clear that the second and fourth applicants are collateral damage of factionalism and infighting within and outside Safa as an organization. The second applicant does not have a personal or private business relationship with the first applicant herein, Dr. Danny Jordaan, who is the Safa president, or any individual within Safa. The fourth applicant simply had a contractual relationship with Safa and not any individual. There are agreements to confirm this, which are conclusive evidence of a legal relationship between the fourth applicant and Safa. The fourth applicant duly and lawfully concluded a service level agreement with Safa to provide strategic communication advisory services to Safa. The agreement was signed by the second applicant for the fourth applicant and on behalf of Safa by the first applicant herein, Dr. Danny Jordaan, being the highest official within Safa. Safa provided warranties that Dr. Jordaan was duly authorized to sign and or execute the agreement. The second applicant never had any reason to doubt the authority of Dr. Jordaan. The agreement was for an initial period of 12 months, which was extended from 1 October 2018 to 31 August 2019. For its services, Grid Communication and Safa agreed on an initial retainer fee of 80,000 Rand, excluding VAT. Safa's main objective in engaging the fourth applicant was for, inter alia, enhancing its corporate reputation through a structured PR and communication program. In delivering on its mandate, the second and fourth applicants reported to and engaged with various Safa officials and executives, including the former Chief Executive Officer, Mr. Dennis Mambo, Safa's then Communications Manager, Dr. Dominic Chimavi, and Dr. Jordaan. There are various communication with the above-mentioned individuals where they made input into the work provided by the fourth applicant. On 7 May 2018, Mr. Chimavi issued a letter of recommendation attesting, commending, and confirming the services rendered by the fourth applicant on behalf of Safa. Such letter reads as follows: to whom it may concern. This letter serves to confirm that Grid Communication currently provides the SA Football Association with full service integrated public relations services. Their services include 1. Overall strategy development, 2. Development of PR programs, 3. Meetings and account management, 4. Editorial campaigns, 5. Media relations, 6. Crisis communication, 7. Media network sessions, 8. Digital and social media communication strategy and implementation. Safa is highly satisfied with the professionalism of the services received to date and recommends Grid Communication as service providers. Yours faithfully, Dominic Chimavi, Safa Head of Comms. The second applicant was never aware of any intricacies or authorizations within Safa. Safe to state that the second applicant, Dr. Jordaan, was the highest official and there was nothing which was raised to question his authority. In any event, the second applicant relied and acted on the basis of warranties of authority provided by Safa and never questioned. Throughout the engagement with Safa, no one ever raised or questioned Dr. Jordaan's authority to sign the agreement, including Mr. Mambo. In fact, at all material times, Safa provided warranties that Dr. Jordaan was duly authorized to sign and or execute the agreement. The second and fourth applicants never had any reason to doubt the authority of Dr. Jordaan. In the many agreements over a period of 2 years, and for the duration of the agreements, none of the Safa officials or executives, including Mr. Mambo, communicated to the second or fourth applicant that its agreement with Safa was unlawful or otherwise indicated that Dr. Jordaan had not been authorized to conclude the agreement. Further, at no stage in all its engagements over the duration of the contractual period did any Safa officials or executives, including Mr. Mambo, communicate to the second or fourth applicants that Safa had not followed the organization's requisite procurement procedures, if at all there were any. Doctrine of ostensible authority. It must be considered that the second and or fourth applicant was a third party and only a service provider to Safa. In concluding the said agreement, there was an appearance of authority that a due and justified impression existed that Dr. Jordaan was authorized to conclude and or sign on behalf of Safa. The second and fourth applicants were entitled to rely on the status of Dr. Jordaan as the president of Safa. In particular, that he has ultimate authority, or at least authority, to sign or conclude agreements and bind Safa. Dr. Jordaan held himself as authorized, and other Safa officials by their conduct, including Mr. Mambo and Mr. Hluyo, also gave the impression of such authority. The second and fourth applicants cannot be blamed if Dr. Jordaan did not have actual authority to sign the service level agreement in question. The second applicant would be justly entitled to rely on the legal principle of ostensible authority. Ostensible authority is authority as it appears to third parties, thus excusing the absence of actual authority. Other parties are entitled to rely on apparent authority, taking into account inter alia the position of the agent. In this case, Dr. Jordaan was and is the president of Safa and is the highest official. It follows that to third parties, his authority was unquestionable. It is perhaps important to explain ostensible authority in the light of the legal considerations by the courts, in particular the Constitutional Court in Makate versus Vodacom Pty Limited. The Constitutional Court gave extensive attention to the principle of ostensive authority. In that case, this considered whether a director had authority to bind the company in negotiations in relation to a transaction with a third party who happened to be an employee of the company. The Constitutional Court pointed out the objectives of the principles achieving justice. Your Worship, I will not read paragraph 65 of that Constitutional Court judgment. I'll proceed on paragraph 37. The Constitutional Court then had particular regard to the position of the director and the apparent authority it gives to third parties. Again, I will leave that to Your Worship. It is part of the submissions. Paragraph 38. This passage is particularly important and fits hand in glove in this case, where Dr. Jordaan's position created an apparent impression that he was authorized to bind Safa in concluding agreements, such as the one between Safa and Grid Communication. No one can reasonably question the highest official to bind Safa. The English case of Haley Hutchinson versus Brayhead Limited and another lucidly made this point. Again, Your Worship, I'm just making reference to this case as it is very important. Even English law, Your Worship, supports the second and fourth applicant's contentions. Paragraph 40. Safa and other officials other than Dr. Jordaan also created an impression that Dr. Jordaan was authorized. Apart from creating an impression, there is acquiescence conduct from other officials, such as Mr. Mambo, engaging with the second and fourth applicants in the knowledge of Dr. Jordaan's signature. In the case of Krista Nominees Pty Limited and Calabria Community Club Limited, the Supreme Court of New South Wales, I again quote what the Supreme Court held all the way to page 18, Your Worship. I'll proceed on paragraph 41. It is thus clear from the engagements between the second and fourth applicants and Safa officials, including Mr. Mambo and Mr. Hluyo, the third applicant herein, that Safa and its officials accepted and or acquiesced to Dr. Jordaan's authority. It is further important to note that neither the second nor the fourth applicant is or was privy to Safa internal processes, delegations, or approval authorities, internal compliance steps prior to or accompanying certain decisions. Your Worship, I then make reference to section 20, subsection 7 of the Companies Act, insofar as it also supports the second and third applicants' contention. Paragraph 43, the second and fourth applicants dealt in good faith with Dr. Jordaan and other officials and were well entitled to presume that all Safa internal policies and formal requirements had been complied with. In fact, in concluding agreements, Safa gave out and represented to the second and fourth applicants that Dr. Jordaan had been duly authorized. The aforesaid is also part of the common law in terms of the Turkwan rule in the case of Stand 242 Henry Port Heater Road, Ramsik, Pty Limited, and Gable NO and others. The Supreme Court highlighted this rule. I quote again, Your Worship, on paragraph 12, where the Supreme Court highlighted the rule. Paragraph 45, the second and fourth applicants can be excused, therefore, for relying on the ostensible authority of Dr. Jordaan based on their aforesaid authorities and submissions. Safa and its officials gave the impression of authority of Dr. Jordaan to conclude the commercial agreement in question. Any of them are stopped from belatedly objecting to Dr. Jordaan's authority. This is espousing on the doctrine of estoppel, Your Worship. Otherwise, all the Safa officials, including Dr. Mambo, should then be equally charged, as they were part and parcel of the agreements and implementation thereof. What is also important is the consideration of intent. Neither the second nor the fourth applicant had any intention to commit any crime. Rather, the intention, as was the case, is the proper and due rendering of professional services. For those services, in dealing with abuse of process, Your Worship. It is the second and fourth respondents' respectful view that the criminal complaint and the charges constitute an abuse of the court process and the administration of justice. It is up to commence with a quote from the court's abuses of process and a court's power in relation thereto. Your Worship, I then quote Solomon versus Magistrates Pretoria, which deals with the taking out of a summons, where the court held that would be clearly an abuse of the process of the court, in that it had been undertaken not with the object of having justice done to a wrongdoer, but in order to enable the prosecutor to harass the accused or fraudulently defeat his rights. I proceed on paragraph 50, Your Worship. This matter falls within the four corners the court identified in Solomon versus Magistrates Pretoria. What the second and fourth respondents are faced with is a manipulation or misuse of the criminal justice process so as to deprive the accused of a protection provided by law or to take an unfair advantage over the accused. It is apparent that there is a concerted attempt to eliminate Dr. Jordaan from his position as Safa president and settle Safa battles using the criminal justice system. In Philip versus Botha, the court defined abuse of process to mean, I'll read this, Your Worship, the process is employed for some purpose other than the attainment of the claim in the action. If the proceedings are merely a stalking horse to coerce the defendant in some way entirely outside the ambit of the legal claim upon which the court is asked to adjudicate, they are regarded as an abuse for this purpose. The courts have said it on numerous occasions that a court confronted with an abuse of process is empowered and should prevent it. Such abuse undermines the justice system and its administration. In Hudson versus Hudson and another, the then Appellate Division, now Supreme Court of Appeal, held, when the courts, open quote, when the court finds an attempt made to use for ulterior purposes machinery devised for the better administration of justice, it is the duty of the court to prevent such abuse. In an earlier case of Nedco Bank Limited and another, the court held, Your Worship, I beg leave to read what the court held in that case, as well as the quote again in Solomon versus Magistrates. The citations are at the foot of the page, Your Worship. I'll proceed on paragraph 55 at page 26. The abuse of process is inimical to the administration of justice, the rule of law, and ultimately constitutionalism. Legality and lawfulness are part of the fundamental principles of our constitutional democracy. We need not restate the numerous cases from the Constitutional Court emphasizing this. Your Worship, at the foot of the page, 5 cases are cited, Your Worship. Legality extends to the exercise of all public power, including that of instituting and discontinuing prosecution. It includes issuing and executing warrants of arrest. Given this country's past, it is even more important to ensure that the criminal justice system, law enforcement, prosecution, and the judiciary is used appropriately and properly. It must be free from political interference or abuse. It must not be abused to target political rivalries, settle scores, or for other nefarious purposes. It is for this reason that the justice system values and principles include fairness, independence, and acting without fear, favor, and prejudice. Needless to state that the criminal justice system has an impact on one of the most sacrosanct human rights, the right to freedom and security of the person. This is Section 12C of the Constitution. In a number of cases, the courts have emphasized that if prosecution is used for ulterior purposes, then it would constitute a breach of the constitutional principle of legality. In National Director of Public Prosecutions versus Zuma, the Supreme Court of Appeal held as follows. I will beg leave to omit reading what was held there, Your Worship. 59, abuse of process is not only limited to improper motives, but is also in relation to vexatious and frivolous proceedings. This necessitates the consideration of merits of the particular matter. In this instance, we have to consider the facts and merits of the allegations, complaint, and charges. If the allegations, complaint, and charges are plainly unsustainable, then they would be frivolous and vexatious. Such prosecution of the charges would constitute an abuse of process. The allegations against the second and fourth applicants are feeble and foible. They have no basis in law and in fact. An abuse of process has also been found in circumstances much like the present, where a litigant approaches the court or the justice system with unclean hands. Your Worship, I proceed to quote the case of Mon versus Zuma and others in the court citing the Constitutional Court, paragraph 95 and 96 of that particular judgment, Your Worship, is cited there. Next page, paragraph 62. The complainant in this matter comes with unclean hands. He is mala fide and dishonest. The doctrine of unclean hands refers to the conduct of a litigant complainant. A court does not assist a party who seeks to advance a claim or case that is obtained or instituted dishonestly or with mala fide. Thus, where the complainant sets in motion the justice system for mala fide or nefarious reasons, and he is then with unclean hands, with unclean and toxic hands, with the justice system, should be protected from. In this instance, the complainant seeks to shadow allegations against him by reinventing spurious and baseless allegations which, in any event, have been dealt with. The complainant is acting mala fide and dishonestly. His complaint, together with various witness statements, is replete with untruths and speculation, just to achieve the prosecution of the second and fourth applicants for ulterior purposes. If the issuing of a warrant, summons, or institution or continuation of prosecution is found to be an abuse of process, then it should be set aside. We submit that another point to consider is that the continuation of the criminal proceedings should be stayed, as there is a same dispute between the same parties for the same relief. Alternatively, the question in respect of the warrants of arrest and obtaining evidence is an issue that will arise within the trial. As such, it is only prudent that, since it is already before another court, it must be finalized while the criminal prosecution or proceedings are stayed. Your Worship, I then proceed to deal with the doctrine of lis pendens and staying continuance. Lis pendens is a form of defense often raised in litigation by a party, usually the defendant, claiming that there is pending proceedings between the same parties based on the same cause of action or for the same relief. The objective of the plea or defense is to stay, albeit temporarily, the proceedings where the plea is being raised. The CRIPS requirements were set out in National Shogun Breweries Limited, trading as Vivo African Breweries versus International Liquor Distributors Pty Limited, where the Supreme Court held. Your Worship, I beg leave to dispense with reading what was held there. Paragraph 68. Lis pendens is about avoiding the replication or duplication of litigation between the same parties in respect of the same dispute. The prior instituted proceedings must be the one finalizing the dispute and not another court where the defense is being raised. In essence, the defense non-suits the court, who must then defer it to the court already seized with the matter. In Caesarstone S. Yam Limited versus the World of Marble and Granite 2000 CC and others, the Supreme Court of Appeal, while defining the defense of lease pendants, also contextualized its basis. I beg leave to dispense with reading what was held there again, Your Worship, for expedience. The defense of lease pendants is important for a variety of reasons, which include avoiding the risk of contradictory pronouncements on the same subject between the same parties, ensuring finality in litigation, avoid wasting resources where the latter proceedings may be rendered a nullity when the underlying cause is obliterated. The plea of lease pendants is considered by the court, which exercises its discretion whether to uphold it or not. It is generally accepted that once the requisites of the plea, as explained above, are established, the court should be inclined to uphold it, being the defense of lease pendants. However, it is important to note that the plea of lease pendants is not final or fatal, as it were. It is simply dilatory in the sense that if the plea succeeds, the proceedings are stayed pending the outcome of the pending litigation. One of the proceedings, likely the latter proceedings, because of its prima facie vexatious, to bring two actions in respect of the same subject matter. The multiplicity of proceedings may be a cause of concern, and it is likely an instance of vexatious proceedings or abuse of court process, like in this case. We submit that the court should prohibit exercising its powers to entertain parallel litigation between the same parties and in respect of the same cause of action or same subject matter. There is also a further concern, which we submit is actually more compelling to uphold the special plea of lease pendants, alternatively, the object of the proceedings continuing. The court has inherent powers to regulate and or control its process. In exercising this power, in every instance, the court considers the interests of justice. In the latter inquiry or consideration, the prejudice to the parties is also considered. It is the prejudice, if the prejudice is manifest and irreparable, the court is likely to protect the party that would be suffering the prejudice if the circumstances warrant. The prior proceedings go to the root of the causa of the dispute. The prior proceedings are determinative of the issues. If the applicants obliterate the warrants of arrest and seizure, then the consequent proceedings stand to fall away. If the causa of the latter proceedings does not exist, then they surely must end. We submit that the present proceedings should be stayed. The principles applicable in suspensions pending the appeal and suspension of execution pending rescission applications are instructive. Your Worship, reference to various cases are also quoted at the foot of the page there, Your Worship. Quite a few cases are quoted. It would amount to a real and great injustice to the persons concerned to continue defending a case when the causa is being challenged and is even highly likely to be set aside. The applicants will be forced to plead and run a defense at great prejudice, expense, effort, and time. By the time the case is withdrawn on the failure of the causa or substantial or irreparable injustice would have taken place. Moreover, it would be contrary to the interest of justice and administration of justice to continue proceedings when the causa is being challenged. There is also high risk of wasting the court's and the state's resources and time. There is also a further dynamic which should be kept in mind. The proceedings already instituted between the parties relate to the unlawful obtaining of evidence which the state has relied on in drawing up the charges and prosecuting. It goes without saying that if a court orders that the evidence was obtained unlawfully, then the prosecution should fail. Its basic and fundamental premise would have been fatally destroyed. Anything consequent or sourced from such evidence could be sustained. In the totality of circumstances, it is in the interest of justice and to avoid substantial prejudice to the applicants that the latter proceedings be stayed pending the challenge of the warrants of seizure and that of the arrests which are pending. I then proceed to deal with the context of this matter, Your Worship. This matter falls squarely within the ambit of what the courts, including the Supreme Court of Appeal and the Constitutional Court, have admonished and condemned as an abuse of process. Its history demonstrates that it is a bitter fight. The complainant and his associates seek the assistance of law enforcement agencies and the prosecution to settle his cause. This should not be permitted. It should not have been permitted by the police and the prosecution in the first place. Further, the allegations made by the complainant are patently unsubstantiable. The criminal complaint and subsequent proceedings are part of a devious stratagem to remove Dr. Jordaan as president of Safa. They are also aimed at removing other senior Safa executives. It is clear that the complainant, supported by various others, intend to use the Directorate of Priority Crime Investigations Unit and the National Prosecuting Authority as a tool of a step-aside prototype and basis for a motion of no confidence in Dr. Jordaan. The complainant and his associates seek to settle political and internal Safa battles using the criminal justice system. Put differently, the complainant and his associates are using the prosecution for ulterior purposes and in abuse of law enforcement and court process. This should not be permitted. Taxpayer money should not be used for ulterior purposes and for individuals to settle their narrow fights. The allegations by the complainant are self-evidently unsubstantiated and without merit. The criminal justice system is being used by the complainant and his associates, even within the justice system, in terrorism against the second and fourth applicants. The use falls squarely within what the courts have termed an abuse of process. The institution of criminal proceedings and the issuing of a warrant of arrest unjustifiably is the classical abuse of the process of the court, undertaken not with the object of having justice done to a wrongdoer, but in order to enable the prosecutor to harass the accused or fraudulently to defeat his rights. The proceedings are a stalking horse to coerce all accused persons in this matter. This should not be permitted, as it is against the principle of legality and undermines the justice system and its administration. The conduct of the law enforcement agencies in this matter demonstrates a disregard for the law, constitutionalism, and the justice system. They are partaking in the calculated abuse of process to deal with and embarrass the second and fourth applicants to settle Safa political scores and or for ulterior purposes. In this regard, the law enforcement agencies and prosecution themselves are abusing their constitutional powers. It is imperative for the court to stop and prevent such abuse of process and undermining of the justice system. An abuse of process constitutes contempt of court and an obstruction of the justice system. Contempt of the justice system should be condemned in the strongest terms, as it creates a dangerous perception about the justice system to the public. In the case of Secretary for the Judicial Commission of Inquiry into allegations of state capture, corruption and fraud in the public sector, including organs of state versus Zuma and others, the Constitutional Court warned, I quote there paragraph 27, Your Worship, I proceed on paragraph 89, it is therefore important that in considering whether there has been an abuse of processes, regard be had to what an abuse of process is in a constitutional democracy, as was pointed out by the Constitutional Court. This applies to the present matter for both the complainant and the law enforcement agencies or officials inappropriately assisting him. I submit that the complainant and those officials aiding and abetting him have abused court processes and obstructed the criminal justice system. This, I respectfully submit, is contempt. As long a quote as is, it is apt to quote what the court said in Kotsia versus National Commissioner of Police and others in expressing its displeasure in respect of abuses of the public system. The court held, Your Worship, I beg leave to dispense reading into the record the very long quote which spans 4 pages. I'll proceed to paragraph 91 on page 44. In the totality of the circumstances, this case has manifest features of an ill-conceived and ill-fated prosecution. it is patently clear that when all the factors and considerations are made, the continued prosecution is not only unjust, unfair, prejudicial, but also constitutes an egregious abuse of process. From the consideration of the fact, we can clearly see that the complainants and some officials are clearly abusing the administration of justice and using the court system for ulterior motives, mainly to settle nefarious battles. Any person can see the charges, can see that the charges are baseless. In particular, is against the second and fourth applicants who are simply collateral damage in Safa internal and political battles. We respectfully submit that this court, we respectfully request this court to save the justice system and prevent an abuse of process, both from the complainants and the law enforcement agencies and officials partaking in the complainant scheme. Your Worship, just in closing, my learned friend for the state indicated that following the preliminary representations that were made to the Deputy Director of Public Prosecutions, Advocate Gideon Kwana, the state has taken a decision to conduct further investigations. This matter spans all the way from 2020, Your Worship. 4 years later, my learned colleague for the state is still coming to this court, informing this court that further investigations have to be conducted by the state. Your Worship, this, besides the fact that there's pending High Court litigation, is prejudicial on the part of the applicants, applicant 2 and 4. Your Worship, Advocate Gideon Kwana yesterday, I've got the utmost respect for Advocate Gideon Kwana. I've known him for several years in my many years of practice as an attorney. I've got the utmost respect for him, but I was very disappointed, Your Worship, yesterday when, following the second and fourth applicants having provided the Deputy Director of Public Prosecution a voluminous liver arch file consisting of evidence proving the fact that services were indeed rendered by the second and fourth applicant before you today, Your Worship. One of the reasons provided by Advocate Gideon Kwana in rejecting the preliminary representations, refusing to withdraw the charges, he indicated simply that according to one of the state witnesses, Mr. Dennis Mambo, the plethora of emails submitted to prove that services were indeed rendered and that Mr. Dennis Mambo instructed the second applicant to render services repeatedly. During the contractual periods, Your Worship, he indicated that Mr. Mambo denies having transmitted any of the emails. Such emails are fake. This is a contention by a senior Deputy Director of Public Prosecutions who has not even tested the veracity or proven whether such emails are indeed false, Your Worship. This is one of the many reasons why it is my humble submission that there is an abuse of process. The state, knowing full well that there is pending litigation in a higher court addressing their conduct, elected to ignore that and decided to have this matter enrolled for nefarious reasons, purely to harass and victimize the applicants here in Your Worship. It is on that basis, Your Worship, I'm simply electing that particular aspect to indicate an evidence that it is irrational for a senior advocate, a Deputy Director of Public Prosecutions, to come to a conclusion and put it in writing to say, my complainant does not recall having received or sent any of those emails attached on the voluminous bundle of the documents that were presented to the NPA for an objective decision to be made. Mention was made by my learned friend that they're prosecuting without any fear or favor. There is too much pressure on the part of former officials of Safa who are putting too much pressure on the state. Hence, the letter, Your Worship, is you've got the letter. It's attached to the state's reply to the submissions that were submitted to the state, Your Worship. It is a letter addressed to me, dated yesterday, Your Worship, by the Deputy Director of Public Prosecutions, where at the end, Your Worship, the second last paragraph, he makes such an embarrassing averment in that just because a complainant has advised him that he has not sent any of those emails, Your Worship, over 50 emails were provided, only from Mr. Mambo. He accepts such bold allegation without even requesting the state to objectively investigate and satisfy itself whether or not such evidence, Your Worship, is fake, as the word is used, Your Worship. In closing, Your Worship, my humble submission is that the court, in exercising its value judgment, has the power to remove this matter from the roll. This is only the third appearance, yes, Your Worship. However, there is substantial prejudice in light of the fact that this court cannot ignore pending litigation on aspects which are pertinent to any further conduct of these proceedings, Your Worship, as far as they're concerned, Your Worship. This is my address, Your Worship, unless the court would like to hear me on any other aspect I may have left out.
Just want to inquire if the representation, are you saying that the representation submitted to the DPP office in respect of accused number 2 and 4 were unsuccessful?
Yes, Your Worship. Fortunately, Your Worship, Section 24, subsection B of the NPA Act 32 of 1998 provides that the Director of Public Prosecutions as well as the National Director have the power to review such a decision, Your Worship.
Yeah.
As the court pleases.
Yeah, the section 22, if I remember.
Yes, Your Worship.
Okay. It's okay. Thank you,
As the court
Mr.
pleases.
Devon. Advocate.
As a court pleases, Your Worship. Your Worship, may I
I realize I have attached all the necessary documents on the heads that I'm hearing, and I realize Your Worship's heads only have one attachment, which is marked Annex 1. Thank you, Your Worship.
You're welcome.
Your Worship, I'll dispense with reading the heading of the heads and go straight into the first point, the application of Section 342A. I submit that the application brought by the applicants is nothing but the abuse of court processes and a waste of the court's precious time and resources. Section 342A reads as follows. Your Worship, my colleagues have read the Section 342A before. I would not like to labor the record unnecessarily by repeating what have been stated already. I would therefore skip the reading of Section 342A as it appears in the Criminal Procedure Act 51 of 1977. However, I would move to point number 4, consideration of subsection 1 of Section 342A. In considering subsection 1 of Section 342A, one has to determine if there has been a delay in the proceedings or in the completion of the proceedings. The matter was brought before court for the first time on the 13th of November 2024. The bail proceedings were commenced and completed on the same day, and the matter was then remanded to 5th December 2024 for disclosure. On the 4th of December 2024, an email notification advising of applicants 1 and 3's intention to make an application in terms of Section 342A was sent to the state. It is interesting to note that at the time of the email notification, the matter had only been before court once. It is also interesting to note that no notice was given to the state in court and on record on the 13th of November 2024. I submit that the applicants could not give such notice on the 13th of November 2024 because
They could not, and they still cannot, prove the existence of any delay in the completion of the proceedings. The subsection is very clear and unambiguous, as it refers to the delay that is being experienced. The subsection does not refer to the delay in future, but the context of the subsection refers to the present delay. If it was the intention of the legislature to refer to the future delay, Section 342A subsection 1 would have been written in a clear and unambiguous manner that provided for such meaning and understanding. Now the question is, was there any delay that was caused on the 13th of November 2024? The answer is no. There was never a delay on the 13th of November 2024. The matter was before court for the very first time on that day. Even after the 13th of November 2024, there was no delay in the completion of the proceedings. I further submit that the meaning of the delay in the completion of the proceedings referred to the causing of the proceedings to be slow or late. Nothing that has been done up to so far suggests that the proceedings have been slowed down or are late. Furthermore, the delay should also be unreasonable. The section does not necessarily provide that the court shall investigate any delay, but a delay that appears to be unreasonable. I reiterate that for the court to decide on the issue of unreasonableness, the delay should first be identified. Without identifying the delay, one cannot speak of unreasonableness. This is now a clear context in which the subsection should be understood. One cannot determine the unreasonableness of an action that has not happened yet. I submit that the state has not requested any remand of the matter so far, but all the two remands have been at the instance of and for the benefit of the applicants. The first remand was for the disclosure, which was inevitably requested by the applicants, while the second remand was again requested for this application by the applicants. Therefore, the claim of unreasonable delay in the proceedings is unfounded and should be dismissed. I'm now turning my attention to consideration of the factors in subsection 2 of section 342A. Subsection 2A, the duration of the delay. The duration of the delay should be taken into account when determining the delay. I submit that this factor refers to the amount of time that the delay has been in existence. Again, the context of this subsection is that the delay must have existed for some time until the time of the investigation. The court can only investigate the duration of the event that has occurred, but not the duration of something that is anticipated to happen in the future. Section 342A does not empower the court to anticipate and make investigations about the events that might happen in the future. The question now is, was there any delay that existed before and after the 13th of November 2024 that caused the slowing of the completion of the proceedings? And how long was that delay? The answer thereto is that there never was any delay of any duration that this matter encountered so far. Subsection 2B, C, and D. The reasons for the delay, or rather the subsection B refers to the reasons for the delay. Subsection 2C relates to whether any person may be blamed for the delay, while subsection D, 2D, relates to the effect thereof, that is the effect of the delay on the personal circumstances of the accused or witnesses. The factors in subsection 2A, B, and C are also not relevant for discussion in that the delay or the unreasonable delay and its duration has not been established. The submission made in 5.5 above equally applies to the remaining factors in subsection 2E, F, G, H, and I. Now, therefore, there is no basis for claiming the delay upon which an application in terms of section 342A should be entertained.
The applicant's application for formal inquiry in terms of Section 342A should therefore be summarily dismissed, Your Worship. I turn to address the court on the unreasonable delay. Should the court find that there is a basis upon which the application can be heard, I further submit as follows. There is no unreasonable delay caused by the state in the completion of the proceedings. The applicants informed the court during the last court appearance that they will request the disclosure of the docket contents. The applicants only made the formal written request via email for the disclosure of the docket contents on the 26th November 2024 and 29 November 2024. The applicants who made the application on the 26th are applicants, or rather accused 1 and 3. And the applicants who made the request on the 29th are accused 2 and 4. The said request or requests The said requests were not made or emailed to the relevant administrative personnel of the NPA, but to the prosecutor's office. It therefore meant that the state was given only 6 days on which to make the copies of the docket for the applicants. And the said emails, Your Worship, are annexed as Annexure 1 and Annexure 2. They depict the date on which the state received those emails. Your Worship will realize that at the top of the emails is the email sent by the prosecutor to Mr. Wolfart. It was for purpose of printing those out. The issue is at the bottom of the email, Your Worship. It's marked with an asterisk. However, the administrators could not make the copies right away, but had to count the copies first and inform the applicants of the costs to be tendered before any copies are made. Only once the costs are tendered would the copying of the documents commence. I pause here, Your Worship, to further place on record that on the day when the email was sent by the attorney for accused 1 and 3, a letter requesting the copies that was sent was dated the 15th of November 2024, but it was sent on the 26th of November 2024. The reason thereof given was that such letter was made and sent to the state on the 15th of November, but up to today no such letter has been found by the state or the prosecutor. But it was only received formally by the state on the 26th of November 2024. I continue on paragraph 7.4, Your Worship. Therefore, no copies will be made before any costs are tendered. Based on the aforesaid, the state can in no way be held liable for the delay in making those copies for the applicants. The applicants' attorneys regularly attend to the criminal matters in this court and are familiar with the administrative issues relating to the request for the disclosure of docket contents. They cannot therefore claim ignorance or unfamiliarity with the administrative processes of requesting the disclosure of docket contents. The delay was solely caused by the applicants themselves by making a formal written request very late. And further, Your Worship, I pause to mention that I also realized something very interesting when I had a closer look at the request made by the attorney for accused 2 and 4. That is the request that was received on the 29th of November 2024. Of interest, the said request on letterhead did not have any date of any sort on the face of it, Your Worship. And I can only speculate that this was deliberately done not to show that it was made or written that very late, Your Worship.
It was only received on the 29th of November 2024 when the matter was remanded on the 13th of November. So I can only deduce from the lack of date that it did not want to disclose the date on which the application was made, which was very late, Your Worship. Even if the court were to impute the said delay on the state, I submit that such delay was not unreasonable and does not have the effect of causing any prejudice to the applicants or the administration of justice. The application should therefore be dismissed. I now turn to address the High Court motion applications by the applicants. The two High Court motion applications referred to by the applicants are self-created inconveniences or problems by the applicants themselves. The first motion application, which is case number 2024-035799, refers to the review of the search and seizure warrant that was executed at Safa House in March 2024. The basis of the said review is that the evidence gathered through search and seizure operation was unconstitutionally obtained and therefore should be declared inadmissible. The applicants further contend that should the evidence be declared inadmissible, the state's case would collapse as it is dependent on the said evidence. I submit that the aforesaid claims by the applicants are far-fetched, untrue, and just speculations as to the state's case, as the state's case is based on the evidence that was gathered long before the search and seizure warrants were executed at the Safa House. It is therefore not true that the state's case is resting on the evidence obtained through the search and seizure operation conducted at Safa House in March 2024. I further submit that my earlier submission that the applicants' claims are untrue and speculative is based on the fact that the applicants have never had sight of the contents of the docket and determined the evidence upon which the state is relying when they filed the said motion applications in the High Court. It is on record, Your Worship, that the accused only received the copies of the docket last week, and these motions applications were filed somewhere in April, Your Worship. They were not in possession of the contents of the docket, yet they made preposterous claims that the state is relying on the evidence obtained through search and seizure operation carried out at Safa House. The applicants would fail dismally if they were to be put to the proof of the above-mentioned claims. Their claims are not only misleading but outright false. I nevertheless submit that the state is not solely reliant on the evidence obtained through the said search and seizure operation. The state will be able to successfully prosecute the applicants even in the absence of the aforesaid search and seizure evidence. The aforesaid evidence is, however, useful to the state for its supportive and corroborative value, but its exclusion is not fatal to the state's case. I further submit that the negative outcome, that is the declaring of the evidence inadmissible of the review application by the High Court regarding the said motion application, would not affect the continuation of this court's proceedings. The positive outcome, that is in favor of the state, would have the effect of amplifying the state's evidence. The applicants claim that the state's case is solely relying on the said evidence is misplaced and should be disregarded. 24-130713. In as far as it is concerned, it is my submission that this should also be disregarded as it is dependent on the first motion application. This motion is based on the fact that the applicants were arrested while they had filed a notice of motion to interdict the execution of the warrant of arrest against them. This notice of motion to interdict the execution of the warrants of arrest against applicants is premised on the fact that the determination of the first motion application is still pending. I submit that even if the High Court were to find in favor of the applicants in both motions, the effect of outcome would in no way affect the continuation of the prosecution of the accused. In other words, the outcome would not result in the suspension or stopping of the prosecution of the applicants. The High Court can only order in the first motion application that the evidence obtained through search and seizure warrant be declared inadmissible. In the second motion application, it can only order that the respondents be declared to have acted in contempt of court. Nevertheless,
none of these possible determinations has the effect of stopping the prosecution of the applicants. It will be up to the state to decide whether to continue with the prosecution of the applicants or not. I reiterate that the state will not stop the prosecution of the applicants, even if the High Court were to declare the evidence obtained through search and seizure warrant inadmissible. The state has enough evidence upon which to successfully prosecute the applicants. I further submit that the pending determinations of the aforementioned motion applications do not have any bearing on the future prosecution of this matter. The determination in favor of the applicants will have no real effect on the continued prosecution of the applicants, while the determination in favor of the state would amplify the state's evidence. I submit further that the applicants brought the first motion application with a deliberate intention to stall and delay their imminent arrest. They intentionally created a delaying tactic in order to avoid facing the impending criminal charges. I submit that the proper forum to determine the admissibility of evidence obtained through the search and seizure operation conducted in March 2024 at Safa House is the court seized with the hearing of the matter, which is this criminal court. If the applicants indeed hold the view that evidence obtained through the search and seizure warrant was unconstitutionally obtained and therefore inadmissible, they should abandon the state's intention to have the matter remanded indefinitely, pending the outcome of the High Court motion applications. The applicants are therefore presented with a choice of either abandoning the High Court motion applications and let the criminal court deal with the disputed issues, or enduring the lengthy remands pending the outcome of the High Court motion applications. However, with that being said, the state has no intention of requesting longer or indefinite remands pending the outcome of the High Court motions brought by the applicants. The state is only prepared to allow reasonable remand periods on request by the applicants that do not become unreasonable delays. The applicants' insistence on awaiting the outcome of the motion applications is just a pre-planned ploy aimed at creating a delay crisis to be exploited in order to enforce the striking off or withdrawal of the charges against the applicants. On the basis of the aforesaid, there are no unreasonable delays in the completion of the proceedings attributable to the state. And the application in terms of Section 342A is definitely not a proper procedure to request the striking off of the matter for anticipated future delays. Section 342A was enacted to deal with the delays that have already occurred and not the anticipated delays. Furthermore, application in terms of Section 342A is not a pre-trial or mini-trial wherein the merits of the case are being ventilated as if the trial has commenced. I humbly request this Honourable Court to hold and dismiss any temptation and an attempt by the applicants to delve into the merits of the case and create a quasi-trial. The merits of the case are to be presented during the trial stage, and the state will properly deal with the merits and prove its case by calling the witnesses during that stage. The applicant's act of delving into the merits of the case at this stage is a clear tactic aimed at confusing the court as well as a tactic to circumvent the trial procedure. The applicants are challenged to allow the proper trial of the matter wherein they will have ample opportunity to test and disprove the state's evidence. It is a futile exercise to attack and discredit the state's evidence at this stage and expect the Honourable Court to dismiss the state's case without having the matter heard through a proper trial. It is interesting to note that applicants 2 and 4's written representations to the Director of Prosecutions were dismissed. It is attached, Your Worship, as Annexure 1, or rather Annexure 3. The Deputy Director of Public Prosecutions determined that there are reasonable prospects of a successful prosecution against applicants 2 and 4. It is further interesting to note that the said dismissed representations are the same applications or are the same application that is being made by applicants 2 and 4 before this court. I submit that applicants 2 and 4 have already failed in their attempts to have the matter withdrawn, and now the only avenue left for them is to let the matter go on trial and let the evidence be properly tested. I submit further that applicants 1 and 3's application is also premised on the reasons that are similar to those advanced by applicants 2 and 4 in their representations. Furthermore, applicants 1 and 3
also made warning statements during the investigation of the matter, wherein they advanced their defenses to the allegations against them. However, their defenses and reasons were found to be inadequate, and hence their subsequent arrest, Your Worship. In other words, warning statements, a very comprehensive warning statement was made by accused number 1, and attached thereto was also a statement by accused number 3. And it was a comprehensive warning statement that attached all the documents and the defenses. But despite that, Your Worship, we have the accused before court today. What does that say? It says their reasons that were advanced in their warning statements were found to be wanting. The application by applicants 1 and 3 is also premised on the same reasons that were advanced in their warning statements and should on that basis be equally dismissed. Finally, I humbly request this Honorable Court to dismiss the applications by all the applicants, Your Worship. Your Worship, there is also, I would like to quickly refer to some of the submissions made by my colleagues in their submissions. For example, my learned colleague for accused number 1, or rather accused number 2 and 4, referred to the causa, that if there is no causa, then there can never be any case. But in this instance, the causa is there. There is a causa, and it's not even dependent on the determination of the High Court review applications. I have already stated that there is enough and ample evidence upon which the state will be able to proceed with the prosecution of the accused persons, even if the High Court were to dismiss the evidence that was obtained through the search and seizure operation. The causa is there, and it will always be there. It will only be up to the state whether it continues with the matter or not. But there is no reasons for the states for not continuing with the matter, Your Worship. Of interest is the fact that my colleague for accused 2 and 4 referred to the court and showed the court the voluminous archive file which he attached as part of his representations to the Director of Public Prosecutions. It is interesting to note that accused 1 and 3 made, or rather accused 2 and 4 made the state's work even easier by making admissions already in those representations. Now the state's case is even more amplified by those files that are contained.
Don't they have without prejudice?
I beg, yes, Your
There's
Worship.
no heading of without prejudice there.
No, Your Worship. Now, Your Worship, that is some of the issues that have strengthened the state's case. The fact that the DPP, the director, Deputy Director, Mr. Nkwana, or Advocate Nkwana, stated the reasons for denying or for dismissing the representations by accused 2 and 4, does not give accused or the legal representative for accused 2 and 4 a right to really vilify him and question his authority and his intelligence. Representations are not only read and dismissed without having done a thorough job of interviewing the witnesses, obtaining further evidence, Your Worship. The fact that an issue of fake email is referred to does not necessarily mean that no further evidence or no further investigations were carried out and a determination was reached. after such allegation, Your Worship. I find it highly disturbing that the advocate's intelligence is being put into question in this forum, Your Worship. And I take exception to that. In as far as the President of the State is concerned, I have no idea of any pressure placed on the state by, I suppose, the complainants and the witnesses who brought this matter before the court, Your Worship. Like I said earlier, we operate or we conduct ourselves without fear of and favor and prejudice. There was absolutely no pressure that was placed on anyone. And then if any pressure was placed on myself as the prosecutor dealing with the matter, then the same, I believe, is the same to the Director of Public Prosecutions, Advocate Nkwana. And I believe the same was done to the DPP himself, Advocate Chauke, as well as to the NDPP herself, as this matter has gone through all those levels, Your Worship, before it could be placed before this forum. It therefore means the claim that pressure was placed on the state cannot be true. If the court may just bear with me, Your Worship. Now, my colleague for accused 1 and 3 referred to the fact that it is unjustified and undignified for the accused to be called back to this court. It now appears that as if accused 1 and 3 should have special treatment, cannot be brought before this forum and be treated like any ordinary citizen of this country, and it would appear that they should not be subjected to the same rules, laws and procedures that are applied to everybody in this country, Your Worship. If by coming here that dignity is being lowered, that cannot be, Your Worship. Anyone against whom a criminal charge has been registered and has been brought before court through the warrant of arrest, summons, or any other matter that brings him before this forum has to abide by the law and come to this forum. It's not only certain people who are supposed to come before this court. Everyone is equal before the law in this country, Your Worship. There are no special persons that have to be given special treatment, Your Worship. My colleague for accused 1 and 3 again referred to a call for a step aside kind of a situation. He even referred to the ANC. Whether there is such a call or such a kind of situation in Safa, it has nothing to do with this court, Your Worship. The fact is, the accused are brought to this forum to answer to the allegations brought against them. Whether in their respective organizations or associations they are required to step aside or resign or take leave, it has nothing to do with this court, and it has nothing to do with the continuation of the prosecution in this forum, and it has nothing to do with Section 342A. It's not one of the reasons upon which this court can find that there is an unreasonable delay. I totally do not find any relevance to that aspect, Your Worship. My colleague further referred to the case wherein it was very clear that the Section 342A was being addressed with regard to the awaiting trial prisoners. Here we have the accused persons who are on bail, who were given bail from the first day, who are still free to go out, even to fly out of the country for that matter, Your Worship. So I do not see any reference or any comparison between them and the litigants cited in that case, Your Worship. There is no relevance here. Of importance that was cited in that case is that the accused cannot enjoy the provisions of Section 342A if he is the primary agent of the delay. And the same appears here, Your Worship. The accused before court are the primary agents of this delay. Had they not taken the matter on review to the High Court, we would not be talking about this delay. And it's not like they did not have any choice. They knew very well that this is a matter for a criminal court. The criminal court is the best forum to deal with issues of in this particular instance, relevant to this matter, this criminal court is a relevant forum to deal with this. By taking the matter to the High Court, I can only assume that they had anticipated the imminent arrest. And in order to circumvent that and to stall that, they had to bring the matter to the High Court. And in doing so, they even used the untrue reason and a misplaced reason that evidence which they are challenging is the evidence upon which the state's case rests. Unfortunately, that is not the truth. And the state is able to proceed without that evidence if it comes to that situation, Your Worship. And those are my submissions, Your Worship, unless, of course, Your Worship would like me to address Your Worship on any other aspect.
Thank you, sir. Thank you so much.
As a court, please.
Do you have a final address?
Yes, my lady. My lady, this is a football matter that should be resolved in the forums of Safa. There are ample dispute resolution processes for it to be resolved there. It is common cause that it was not done by those who are on the witness list and the complainant whilst they were in a position to do so. In other words, while they had standing to raise these issues within those forums, they failed to do so. It is only after they were either suspended, dismissed, or were not voted back in. So this constitutes an abuse. The matter has in fact, and my learned friend hasn't addressed it because he can't. The charges or claims of theft and fraud is outrageous. I made the submission this morning, the whole day. My colleague hasn't addressed it. It has gone through the processes, the audited financial statements, which requires the CEO and chief financial officers to make material disclosures. These disclosures were never made, including by Mumble when he was the CEO of Safa. This, my lady, happened under his watch. It went to the National Executive Committee, it was approved. It went to the annual Congress and it was approved. There is no basis for this charge. And that explains why my colleague cannot address it. Now, to say that the delay has been caused by the accused running to court in anticipation of being arrested Now, the second application was in anticipation of being arrested. Why? Because the investigating officer, who has conducted himself in a totally unethical and unlawful manner, phones up the instructing attorney of the accused on the 7th of November and tells him, I'm coming to arrest you guys.
But Advocate Norman Arendse, the reason I requested you to address, it was just in reply. It looks like you're starting afresh again what you addressed in the beginning. I just want to make sure that I follow you.
My lady, I respect that, but this is in response to my learned friend saying that these applications brought in the High Court is to avoid being held accountable and is to avoid being arrested. And I'm addressing that issue expressly, my lady. My lady, you know the application was quite substantial. I went, compared to my colleagues, I went through it relatively quickly. I had short heads. And I'm in minds that there was unfair unconstitutional or illegal conduct in pursuing, one, a search and seizure, and two, an unlawful, unconstitutional arrest. It has implications for this trial, my lady. And it has implications. My learned colleague, the prosecutor, says, oh, well, you can separate out. Whatever they found there in the illegal, even if they find that it was an illegal operation, we don't need that. So what? It just begs the question: why did you have the search and seizure in the first place? He says, quite rightly for a change, he said, accused number 1 made a comprehensive witness statement, and so did accused number 3. My lady, when did they do so? In November 2022 and in December 2022. So why the need for a search and seizure operation in March 2024? It could only have been to embarrass the accused and to intimidate them. But what is worse, my lady, these warrants are not accompanied by affidavits, and that is in dispute in the High Court. And in fact, if your ladyship has regard to those papers, they are not disputed, my lady. Now, in relation to those applications, my learned friend, the prosecutor, says, quite rightly, even if there, he has to concede this, even if there is a lengthy remand, we can still continue with this case. It is just not possible, my lady. I read back to your ladyship the case law, and I also submitted to your ladyship that this case is different from a run-of-the-mill case. The Constitutional Court has also said those factors that are listed in 342 capital A subsection 2 from A to G or I or whatever, those are factors that the court will look at, but none of them are decisive. It's not a tick box exercise. This case is different, and to now opportunistically, because the media is there, that the accused think that they're above the law and they want to be treated differently. It's totally unfair and to make such an allegation, my lady. The application is brought because the state, the investigating officer in this case, and if his conduct is found to be unlawful and unconstitutional, it has implications for whatever he did. Why? because we know this case dates back to 2020 when Muka first lodged the complaint, and even before that, when I read that letter to your ladyship that Mumble wrote to everybody involved in Safa and said these attacks on Safa. So it's a long running issue which has now been escalated to this by former football administrators, former employees of Safa, using the levers of the state in an unfair and unconstitutional manner to achieve their ends. The rules are clear, they have not been used, my lady. So, my lady, the submission that, and I wrote it down specifically because I don't want to misquote him, even if the motions in the High Court are in favor of the accused, it won't stop the prosecution. I just can't get my head around it, how it would be possible, my lady, that the conduct of the investigating officer in the case, the same person who has collected these witness statements dating back several years, can now simply be said that despite his conduct, there's been no irregularities in the conduct of the proceedings up until this stage. It has a material effect on the outcome of this case. And again, to say that this is now a delaying tactic. Our case, my lady, is quite simple and eminently reasonable. He admits, he concedes that there may be a delay, but he says, you caused the delay. Okay? You caused the delay. But he admits there's a delay. The effect of that delay, we say, my lady, given the High Court role, and the other thing he hasn't touched on at all is the DPCI investigation into the investigating. That didn't deal with it at all. So those three things are going to take time. All we're asking, my lady, it's not a victory of some sorts. Remove the matter from the roll. We know in this country judicial resources are scarce. There's other cases that he can deal with and that he must deal with that are priority cases. Remove it. Let's await the outcome of those cases. And if the Director of Public Prosecutions or the NDPP, if they're minded to have the matter re-enrolled, then we'll be back in court, my lady. It's different from having the case, from the stopping the prosecution or from dismissing the charges. I think that's it. Sorry, the other thing was the my learned friend keeps on saying that a request for the docket was only made on the 26th. My instructing attorney is adamant that the letter went off on the 15th of November. But even so, my lady, accused persons are entitled to the docket. In our affidavit, which hasn't been controverted, on the when they first appeared here, and when I was not in here, the docket was promised on the day at the first hearing. And you've got to wait almost more than a month before you get a docket, which is still incomplete.
Is it still incomplete even today?
Well,
Because the last time
as far as I've been...
before court, they said it's available, just need to be collected. Just want to make
Sorry,
sure.
my lady, I'll just take this letter. Yes, let me rephrase. We only got the last 5 pages, the last file, on the day of the last appearance, my lady. So that would have been on the, the 5th,
5th of
6th
December.
of December. Now that we do have the file, there is nothing stopping. There is nothing stopping the accused in the High Court matter from amending their papers. My colleague is right. They went to court because it was urgent. They went to court, it was urgent. It involves the individual, the liberty of the individual. It involves their constitutional rights. And they're entitled to have those rights vindicated. But there is nothing stopping them now. I'm not in the counsel in that case. Looking at the docket, looking at the stuff that you brought to court in the first place to amend your papers. But talking about delays, my lady, the delays in the High Court application have been deliberate. I've already mentioned to your ladyship, in the first motion, first opposed motion, the state respondents filed more than 3 months late, and they now have had to apply for condemnation. So, yes, the raid took place on the 8th of March. If the state respondents had timeously filed their papers, the applicants had done their reply, the matter could have been enrolled already. Who's responsible for the delay? They are responsible for the delay. In the second application, the unlawful arrest, they still haven't filed any papers. They're again late. So, my lady, we submit that we have made that a proper case for your ladyship to grant us relief, to remove the matter from the roll, and to be re-enrolled only after the DPP and or the NDPP have had a look at the matter, if they're minded to enroll the matter again, my lady. And we'll, if your ladyship removes the matter from the roll, we ask for the I think with the help of your ladyship,
The bail to be refunded
the bail to be
to the
refunded.
depositor.
I'm not sure if it's going to be enough to pay my fees, but the bail should be refunded.
Okay.
Thank you,
All
my
right.
lady.
Just want to find out, probably just to give, because I'm dealing with a delay here. Though the High Court matters are not within this forum, but it will also help the court as to the progress of those matters in the High Court. I just want to find out the one which was set down for the 14, which was an agent application to
Yeah.
prohibit the arrest.
Yes, my lady.
That application was ever heard by the court on agent basis, the one to prohibit the arrest.
No, it wasn't, my lady.
So it was never.
It was, and the state respondents were aware of it because there was a directive on the 12th when the matter was set down, and this is in our affidavits.
All right.
Justice Wepner directed that the matter be heard on the 14th, and in between that, the investigating officer and whoever led the charge, they decided, no, let's arrest these. So obviously the urgency for that fell away, but
Okay.
it's still in
So it's
court.
going to be the normal service.
Yes.
It's going to take the normal service. The agency is gone out of the window
Yes, my
in
lady.
terms of the
Yes, my lady.
arrest.
And no papers have been filed by the state respondents yet in that matter, my
Okay.
lady.
This other way, one search and seizure, when it was lodged with the High Court, was it also the normal service of the application? There was no agency to that application. It was the normal service.
It was brought in the normal course
Okay.
because the search and seizure had already taken place,
Okay.
and now the legality or unconstitutionality of the service was
So
now placed before the court.
on the one that you said the pleadings had closed, why is the date not obtained for the sitting of that matter?
Because in the first place, the state respondents had filed terribly late, more than 3 months late. Only at the 28th of August, they filed their answering papers.
Yeah.
The applicants filed their replying affidavit within the normal 2-week period, so the pleadings are closed.
Yeah.
And the applicants had also filed their heads of argument, and the state respondents have not yet filed their
So
heads of argument.
You're actually waiting for the heads to place
Waiting
the
for
matter on the
heads,
roll.
and we wait. Then the matter can be enrolled.
All right, the last aspect, advocate, it will be dealing with the cost order. I saw one of your prayers in the notice of application is you prayed for the cost orders. So the court wants to find out, is that subsection in existent? Is it working now?
Yes, my lady.
Of cost order.
Yes,
Thank you.
as the court pleases.
That's all. Thank you, advocate.
Thank you.
Mr. Ndebe?
Your Worship, I'll be very brief. Maybe let me start on this last point with regards to where these proceedings are, the review proceedings. Your Worship, nothing precludes, given what has happened in totality, nothing precludes the state or the defense from approaching the Deputy Judge President of the South Gauteng in marking the conduct of those proceedings preferent, in expediting the process so that the matter can be determined and finalized. The DJP has assisted parties before and can assist the parties given the facts of this matter. I'll proceed, Your Worship. I will not be long. Your Worship, much ado was made by my learned colleague for the state about what Section 342A provides. Please indulge me, Your Worship, by reading Section 342A. A court before which proceedings are pending shall investigate any delay in the completion of the proceedings which appears to the court to be unreasonable. Stop. There's an end, Your Worship. And which could cause substantial prejudice. We're dealing with the end aspect, not unreasonable delays whatsoever, Your Worship. For now, we're dealing with the end aspect in the sense that, Your Worship, substantial prejudice can be caused to the accused in the sense that there is pending litigation in the High Court. When the state decided to ignore such proceedings and have the accused arraigned before court, Your Worship, the horse had already bolted insofar as such proceedings in the High Court. It is not up to my learned friend for the state to dictate to the defense, withdraw your High Court proceedings and deal with your matter in the Magistrates Court. There will not be any exchange of papers. Your Worship, I found such submissions to be mind-boggling, Your Worship. Your Worship, it is trite that the value of evidence can never be underestimated, as evidence can make or break a case. It is therefore important that evidence must be correctly and properly gathered, handled, presented, and preserved with a view to establish a link between an individual and a specific act. In this instance, Your Worship, we're faced with a situation where the entire evidence, Your Worship, has been gathered by the state, whether it was from 2020. However, what has happened, Your Worship, a warrant of arrest was obtained with the view to secure evidence. If a higher court comes and makes pronouncement to say that the search and seizure warrant were unlawful, what then is going to happen to the evidence for the state, Your Worship? The evidence for the state is going to consist of what is normally termed fruit of a poisonous tree. Now, my learned friend for the state wants the court to believe that, no, we can use whatever we had beforehand, blah, blah, blah. Section 342A, subsection 3C, Your Worship, provides a remedy in the sense that the state can reinstitute these proceedings if the court were to strike the matter off the roll on the grounds that a director of public prosecutions, alternatively the national director herself, provides the state written guidelines on what to be done. This case up to now, Your Worship, is peppered with a comedy of errors. A lot has happened, Your Worship. There's a reason why we have a National Director of Public Prosecutions and a Director of Public Prosecutions, Your Worship. They are there to guide and assist junior state officials on how to conduct prosecutions, Your Worship. Hence, the request being Section 342A, sub 3, sub C, in the sense that should a higher court pronounce, as I've indicated, Your Worship, how do you remedy and cure the poisonous tree? It's not up to my learned friend for the state to decide, this is what I'm going to do, 1, 2, 3. There are guidelines, statutory guidelines enshrined in 342A, subsection 3 and C, which would require the state to be guided on what to be done, Your Worship. Lastly, Your Worship, much ado was made about requests for copies. I indicated on the previous occasion, there was no prejudice claimed, Your Worship. My learned friend has got it wrong in terms of the basis upon which this 342A application is sought. It's not with regards to unreasonable delays. Like I indicated earlier, Your Worship, this is the third instance that the matter is before court. We're dealing with the end aspect, the likelihood to cause substantial prejudice, in the sense that there is pending High Court litigation, which is yet to be finalized, which might well pronounce the fact that the evidence of the state consists of fruits of a poisonous tree. There's a manner in which they would have to remedy and deal with that defect, Your Worship. Now, lastly, Your Worship, I did not cast any aspersions to my learned friend, the Deputy Director of Public Prosecutions, Your Worship. I indicated that I've known him and worked with him for many years, Your Worship, and that I've got the utmost respect for him. I simply indicated that it was mind-boggling that when presented with voluminous bundle of correspondence, email correspondence, he gets to be told the emails are fake and ultimately makes a decision to reject the representations on that basis, amongst others, Your Worship. That's all I made, Your Worship. It was a statement that was being made, not intended to cast any aspersions on the Deputy Director, alternatively to vilify him in open court. That was not my intention, Your Worship. I was simply placing an aspect which talks to abuse of process, in the sense that had the Deputy Director of Public Prosecutions intended to objectively assess and satisfy himself whether indeed such evidence is fake, conduct further investigations, as my learned friend said, on that particular aspect, and come to a conclusion upon having objectively assessed and analyzed the evidence before him. That is all I have in reply, Your Worship. As a conclusion.
Thank you, sir. I see that I'm way past 4. I'm worried about the officials that I'm working with. I've taken their time, lunchtime, and everything. However, the ruling of the court it is ready, but because of time constraint, I have to. I'm not sure when can we postpone this matter to. But if the staff agrees to give me few minutes, then I'll run with that so that I can finalize it. Thank you. And I believe the defense as well as the state are also okay about it. I heard you advocate saying that you're catching a flight. Are you okay?
Yes,
You can proceed. Thank you. All right, I'm going to be brief with this ruling of the application just to finalize the matter. I must say that the application for the section 342 capital A of the Criminal Procedure Act 51 of 1977 has been brought by the all accused persons before court. One of the prayers, I must read the prayers as they appear on the notice of application of accused number 1 and 3, is that in terms of section 342 capital A3C, that the matter be struck off from the roll and the prosecution not to be resumed or instituted de novo without the written instructions of the National Director of Public Prosecutions and or Provincial Director of Public Prosecution. That is prayer number 1. Prayer number 2, alternatively, in terms of section 342, capital A3, E, that the state shall pay the accused the wasted cost incurred by the accused as a result of an unreasonable delay caused by an officer employed by the state. The third prayer, alternatively, in terms of section 342, capital A, 3F, that the matter be referred to the appropriate authority for administrative investigation and possible disciplinary action against the prosecutor concerned and the investigating officer in this matter responsible for the delay, and that the matter be removed from the roll pending the outcome of the investigation. I must say that the application by accused number 1 and number 3 is supported by the affidavit, because there's a founding affidavit of accused number 1 as well as the confirmatory affidavit of accused number 3. The accused number 2 and 4, there is no affidavit supporting the application, as well as the state did not file an opposing affidavit to that matter. But the court will state that it is not a requirement that an affidavit be provided. It was just that it carries more weight. That is the weight that is attached. So the court will take the opposition as well as the application of accused number 2 as it is before court. Now, I would say accused number 2 and 4 also is taking the same grounds of this application. But the application is opposed vehemently by the state. The grounds of this application, basically, I would state in summary, is that it is the finalization of the High Court application lodged by accused number 1 and 3 to set aside the search and seizure carried on by the DPCI on the 8th of March 2024 at Safa premises. Finalization of the High Court application lodged by accused number 1 and 3 to set aside their arrest as per the warrant of arrest authorized. The last one, it deals with the conduct of the investigating officer in this matter. Now, the court, I think today we heard what are the requirements of that section 342. But this court cannot provide a ruling without touching, because it's very crucial for this court finding, is that section 342 capital A as amended, I must say that this section was recently amended, provides as follows: that a court before which criminal proceedings are pending shall investigate any delays in the completion of the proceedings which appears to the court to be unreasonable and which could cause substantial prejudice to the prosecution, the accused, or his or her legal advisor, the state, or witnesses. Then it gives the proviso. It says that provided that when the court requires information pertaining to the infrastructure, that is the recent amendment, and I'm not going to read that part because it's not relevant to my proceedings. I'm not dealing with the infrastructure that delay these proceedings. The section deals with the criminal proceedings. The usage of the word shall in that section makes that section to be peremptory for the court to investigate the delays in completion of the criminal proceedings. The delays have to be unreasonable, not only unreasonable, and also cause a substantial prejudice as pertaining to this case of the accused persons. So I heard Mr. Ndebele say that worship we're dealing with the second part of section 342 capital A, where it touches on the substantial prejudice. I think you cannot read that portion in isolation because of the usage of the word and. The moment there is and, it means that it's a joint. You must do it together. So basically, how would I see that there is substantial prejudice if I don't focus on the delay which I see to be unreasonable? To determine if the delay is unreasonable, the court is guided by the factors listed in section 342 capital A2. So I'm not going to read those factors. The people sitting in this court, with the exception of the accused persons, are aware. But it touches on the duration of the delay, it touches on the reasons advanced, it touches on whether any person can be blamed for the delay, and then the list goes. But that list is not exhaustive, meaning that any other factor that the court deems it necessary, it can be considered. I would say that the court has also touched on the case of Sanderson versus the Attorney General, Eastern Cape, 1998, Volume 2, SA, 38cc, as well as Bothma versus Els, 2010, Volume 1, South African Criminal Reports, page 184cc. In both of those cases, the courts mentioned that the permanent stay of prosecution should not be granted lightly. So it's not something that the court can grant lightly. So the wording of section 342 capital A of the CPA, which affords a basis for the magistrate to make an appropriate order on the related delay, is limited to delay after the commencement of the proceedings. In these instances, when did the proceedings commence in the criminal case? They commenced when the accused persons first appeared before this court and a bail application was heard and it was finalized. That is the delay which occurs while the matter is under the supervision of the court, meaning that the moment you first appear as an accused in a criminal court, that matter is under the supervision of the court. So basically the court must ensure that it investigates all those delays. Applying the section to these proceedings, it means that the two High Court matters which accused number 1 and 3 are referring to are not in this forum. Whatever that delays this court must pertain to this forum. This is what the court is interpreting that section. I'm not delayed, but what is happening in the High Court. The High Court is running its own race. I'm running my own race. Hence the state said, if the evidence is obtained unconstitutionally, nothing stops this court during the trial hearing to deal with that matter on an application of a trial within a trial. But this court does not state that the High Court matters should be dispensed with. They can run on their own until I get an order, probably from the High Court, that these proceedings can be stayed. And if these proceedings needs to be stayed in terms of the Taylor matter, this court lacks jurisdiction. There's a matter that emanates from the very same court, which is Taylor matter, and then that matter states that this court, which is the regional court, it lacks jurisdiction to stay the proceedings. So whatever that is decided in the High Court, this court will say, at this moment, the arrest is an issue that has no bearing on this court. How will it stop this court to finalize its mandate? Secondly, it seems that these methods used for these matters are of a civil nature, meaning that when I looked on media, seeing what it was said in the High Court, obtaining dates in the civil section, I was looking on 2029, 2023. So basically, it's going to delay. I'm not sure, as Mr. Ndebele indicated, that the intervention of the DJP can help in getting a date sooner for prosecution of those civil matters. The last ground of the application relates to the finishing of the copies of the docket. The first appearance of accused number 1 and 3 was in November, if not October, was in. To go to the charge sheet. It was in November, I guess. And on that day, the bail was held. There was a partial disclosure. Due to that partial disclosure, the defense informed the court about their intention to proceed with an application. The state further mentioned on the 5th of December that the full disclosure is available and can be obtained by defense. With the disclosure available, which was provided, which was partly, that disclosure was allowed accused number 2 and 4 to submit representations, which representation I'm informed today that they were refused by the DPP, or by the Deputy Director of Prosecution. So the removal of the matter from the roll should be granted by the court as a measure of last resort, because the court, in exercising its discretion based on its finding, can refer the delay to an appropriate authority. So the struck of it will be the last resort. If I find that when I investigate, because the whole day we've been doing the investigation, so if I find that there is a delay, this court has all the powers to refer to the administrative body, which can conduct an investigation and give a finding. And possible disciplinary action against any person responsible for the delay. What the defense is praying for, indirectly, is the staying of prosecution, of which this court has no authority on it, as it's stated in the Taylor case. The court is stating again, the accused persons are not the only person entitled to a fair trial. Yes, I'm saying that everyone appearing before court, that includes the witnesses who have not appeared as the matter started, they're entitled to a fair trial, meaning that the matter should be ventilated. So basically, I'm saying that the witnesses, even though not so muchly covered by the Constitution, but they're also entitled to a fair trial. In essence, accused 1 and 3 applying for the declaration that they should not be prosecuted. If I hear, they are seeking a remedy which would avert their trial, rather than one which asserted their right to a fair trial. So the court has also cited the case of Taylor. The state indicated that the last part of the disclosure is available and can be obtained by the defense. The factors listed in section 342 capital A2 are not present. I must say that I've investigated the matter the whole day. Starting with the first leg, have you established the delay, Worship? I have not identified the delay, taking into account that the matter just started in November. So there is no delay, and this court also has no jurisdiction to stay the prosecution. On that basis, I'm saying that section 342 capital A, it is premature in these proceedings, and this court is dismissing the application. And when it comes to the issue of the cost, probably normally we deal with the cost later. This court is of the opinion that reading the amendments which were recently done, that part of the cost order was not in operation, and this court believes that it will not award any cost. Thank you. All right, I hope the date has been obtained.
Actually, Worship, no date has been obtained. We were mulling over a date during the...
I doubt if we'll still find Mr. Wolfert.
But we spoke to him. We went to his office, and we were quite not sure how to proceed with this. We could not really agree on the further remand or reasons for further remand. So we decided, upon the advice of Mr. Wolfert, that we should at least get the direction from the court itself.
Okay.
We are therefore amenable to dates somewhere in next year, 2025. Had actually touched on the possibility of having this matter remanded to sometime in 2025. Could be late January, early this February. And I'm just not sure what my colleagues would like this application or this remand to be for. We were talking about provisional remand, but provisional remand depends on something.
For what? Maybe
That is
let
correct.
me get guidance from the defense then. I think they will tell me.
If I may, as a state, put my foot forward, my request to them was that this matter can be postponed for trial.
So the matter is trial ready. Is that what you're saying, Mr. Malaka?
Yes.
Your Worship, if I may interject,
All right. Yes, Mr. Ndebele.
we just got the docket.
All right. Can't I give Advocate Norman
Oh.
Arendse first
Yeah.
to respond to that?
Yeah, we just received the docket, my lady. So it will take time, and there's also the matter of perhaps waiting for your ladyship to give us a written ruling.
Okay.
Although your oral ruling
It was typed, but I had to write
Yes.
on it. But I can print it again.
Yes, and we my client and my clients and my attorney may want to take that under advisement, and to see if they want to take that anyway.
Okay.
No, and there is the matter of the High Court applications, and it might be that a further approach to interdict further proceedings might be made. So all I'm saying is that it's very much up in the air, and it would be premature to set the matter down for trial, my lady. At any stage, your ladyship has made a ruling that the High Court matters are not in your court, and you in your investigation you were concerned only with the delays caused in this court. But we say that the two are inextricably linked. It certainly wasn't a point taken by the prosecutor that you shouldn't take into account the High Court cases, and that you should. Nothing was said about the pending investigation also into the conduct of the investigating officer in your written your judgment. Nothing was said there, and so in my view, with respect, my lady, the matter is a long way from being trial ready. In fact, my colleague the prosecutor said this morning there's no other matters that he wants to investigate. So he might want to conduct some further investigations and maybe get some more former NEC members to come to the party and make some statements, my lady. I'm not sure. He said this morning that he's been conducting further investigations. So bottom line is the matter is not trial ready, my lady.
But the state say I'm ready for trial. That's what he said when he requested a postponement.
Well, if he commits to that, then he must do so in writing, my lady, and we'll take instructions.
Should I postpone for instructions? Is that what you want?
Sorry, my
Maybe.
lady.
Should I postpone for instructions? Is that what you want to do?
Yeah, I think maybe just let have a postponement. With respect, very little is going to happen between now and say February, my lady.
Do you have a date in mind?
The 7th of February.
7 February.
It's suitable to the state, Your Worship.
Mr. Ndebele, sir?
Yes, Your Worship, apologies again for having spoken out of turn.
No
I wanted to,
problem.
in fact, suggest this pragmatic approach that we just received the docket. A sensible way forward would be to afford the defense an opportunity to obtain instructions. The 7th of February is suitable. My client is on bail. I would request his bail be extended and be forewarned for the 7th of February.
Can you please rise? Your matter is postponed until the 7th of February, back to court number 9 at 8:30. It is for instructions. Accused 1 to 3, your bails are extended with the same conditions, and you are warned for 8:30. Thank you.
Please.